What is up? Welcome to Defense Diaries, Just Facts. And I am excited to have my host back, my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Hey, so we missed you. We were live yesterday on the case that never sleeps, Delphi. As you know, I told you, and everybody that tunes in with us knows that you're in the middle of a post-conviction relief act, hopefully actually towards the end of your post-conviction relief act petition, I hope. But, you know, it's truly the case that never sleeps. Obviously, there was another filing today, or I'm sorry, yesterday. Actually, there was Baldwin and Rozzi filed their motion to DQ. And then later in the afternoon, McCleland filed what we're going to be going through tonight. However, yesterday I did an early morning live with you laying in bed. So it was weird. I was doing my live while you were there. So I was kind of trying to whisper, but not talk. And I didn't have anybody to get me a drink. And it was like 30 pages that I read through. Just so everybody knows the amount of work that I put in to struggle through that thing. It was a lot. And I did it for you guys because I love you guys. We love you guys.
Yes.
So I just want to kind of go through the nature of what's going on, and I want to get your thoughts on it. So we have the Supreme Court hearing, the oral arguments. They reinstate Baldwin and Rozzi. It's quiet for 2 business days. And I think on the Monday following, we get the order from Gull denying without hearing, 3 separate motions: the motion to suppress, the motion for even a preliminary finding hearing on a Franks, and then as well as the motion in limine regarding the ballistics. And look, like, my position on that is I'm not sweating her on the denial, okay? Because she very well, more likely than not, would have gone to hearing on all 3 and denied all 3 after a full hearing. So I'm not, that's not the part that bugs me. The part that bugs me about what she did is, one, that she did it while we're all still waiting for the Supreme Court opinion to come down, because as we know, we're all still waiting for that. Number 2, that she decided to do it without hearings in light of what the Supreme Court was saying about the record being a shambles in this case. And 3 is the fact that if she's going to do it by order, by written order, include some case law, include like your rationale, your standards. And she didn't do any of that. It's like we have 3 major motions that have been denied with essentially what I would consider to be a minute order. You know what I mean? So it's like she just didn't do anything in terms of the record, which, again, the appellate court relies on it. And those would certainly be issues that would be brought up. So that's where we're at. Like, what is your position on that? I mean, like, we didn't really get to talk about that.
Well, I mean, I think that there should have been a hearing, or like you're saying, there should have been a legal finding in her order, such as, I've taken everything that the defense has said as true for the purposes of this ruling, and find, even if they prove every piece that they have set forth in this motion to be true, I still find that there either was nothing that was misleading or nothing necessary was left out. But even if it was, and everything that you wanted out was out and you wanted in was in, I would still find probable cause, and then it's a non-issue.
In fairness, she kind of did do that. Like, she said at least that.
Oh, okay.
But like, she gave the wrong standard in terms of the Franks. Like, you know what I mean? It's just like, I don't know. It just wasn't what I expected her to do coming out of the oral arguments. You know what I mean? Like, so subsequently, so she does that. Now the case is back to being like, as soon as I started seeing maybe a little light at the end of the tunnel, still with everybody like, oh man, is she going to stay on the case? Is she not going to stay on the case? You know, I'm hoping against hope that she'll be able to just act professionally if she's going to be on the case, and let's get through the damn thing. You know, I mean, she's not going to be able to escape the fact that everybody's going to think that she's biased every time that she rules adversely against the defense. That's where we're at with this thing, whether it's true or not. You know what I mean? It's just how people are going to feel about it, especially the people that have kind of come to the conclusion that something stinks in Delphi. You know what I mean? And I don't know what the source of the stink is, which is the most frustrating part for me. I don't know where it is. And I'm left always kind of grasping at straws. And you know, I'm not huge on speculating, you know, but the fact of the matter is that something's distinctly off about this case in terms of how it's being run. I've just never seen a case like this. It is jacked up, and we talk about Garcia all the time, and I hate to always make the comparisons, but that was like the closest thing that I can remember, short of like OJ. But OJ was like different weird. That was like a judge who had lost control of the attorneys, of the trial, of everything. This is like a whole different level of weirdness that I just have never seen. Like, honestly, like, you know, and I watch a lot of trials. I'm historically, you know, pretty adept at knowing what's been going on in the kind of the world of law for a long time. I'm kind of a history nerd like that, and I'm a law nerd, and I've never seen anything like this. And it's disconcerting for everybody involved, but especially for the girls, for their families, and for Rick Allen. Like, at this point, the only parties that matter in this are the victims' families and Rick Allen. The rest of everybody else are just players in the game. You know, I mean, like, honestly, you know, between McCleland and Andy and Brad and Gull, like, they're interchangeable. The two parts of this that cannot be interchanged are the victims' families, because those two little girls lost their lives, and Rick Allen, because he's the guy that they've arrested and charged with it. Like, those are the two permanents in this thing. The rest of them can all be switched out, and the thing can move forward, you know? And so kind of the way that I see that it went down is you have her kind of going off half-cocked with this straight denial after she didn't do shit with those motions for months. And, you know, like, I don't know what her motive was on that. Was her motive like in theory, it could have been, all right, well, I'm concerned that Brad and Andy are now going to file the 70-day. Okay. And I'm going to try to get in front of that. I'm not going to wait, you know, and I'm going to deny those motions. I like, even if I would have heard them, I would have denied them. I've read the motions. I'm not convinced by the arguments, and that's it. I'm denying them. So those are off her plate in terms of moving forward.
What were the other motions other than Frank's? Were they other motions that are typically ruled on the face of the pleadings?
No, they're motions that are typically, there's a hearing. So it was a motion to suppress.
That one I don't understand. That one, I don't see how she could have ruled without a hearing.
A motion to
suppress. The motion about the, sorry.
A motion to suppress the search of Richard Allen's home. Okay. Always a hearing. Have we ever had a suppression motion ruled on, like, on the paper?
Never.
Never. And
never.
Ever. So, and then the motion in limine on keeping the unspent casing out.
No, somebody needs to let them know they need to file a motion to reconsider. They have to have the ability to present their scientific evidence. I don't understand how they could rule on that on the paper. That one is beyond me, unless I'm missing something. I haven't read the motion in a while. I don't know if all the arguments were in there, or if it was something about the science specifically. How could she?
All right. Well, so she did.
I've never had a motion in limine ruled on without us arguing.
Right,
I mean,
so here's the outrage that I was expecting the first time I asked you this, like 5 minutes ago. So, right. It's unusual. It's very unusual. So then we try to figure out her motive, which is what I was just talking about. It's either she's trying to get in front of them filing a 70-day, which means that the trial is going to happen in 70 days less whatever time is told due to defense stalls. Like if they file motions, that's on their clock. So the thing gets told, right? Or in the alternative, was she trying to beat them out in what she anticipated was coming, which was the motion to DQ? Because the effect of the motion to disqualify means she cannot rule on anything until that is resolved. Right?
My personal opinion is that absolutely was one of the driving forces, that she knows once they file that she can't rule. So she was denying everything right away.
Right.
Which
so, and I think
the motion in Lemonade is the most, I mean, the motion to suppress, I can't remember what the the grounds were, lack of probable cause, or was
it was
hand in
it went hand in hand with the Franks. So it was essentially that, you know, that they didn't have the probable cause to do the search, and that the probable cause that they had was all basically just based on Liggett coming in and lying, or fudging, or omissions, and, you know, not fleshing it out. And, you know, in the search of the house, they end up finding, to me, nothing that was a real smoking gun. You know, I mean, they find the blue Carhartt, which I would hazard to guess a vast majority of people that live in Indiana, in rural Indiana, probably own a Carhartt of varying color.
We had, sorry, when we had our guest on the other day who's written the book and spoken with the family.
Oh, Hendrick, Susan.
Yeah, she specifically said that when this was all like going on and they were looking, that everyone's position was everybody has those. Maybe it was the shoes, but it was something.
No, it was it was the Carhartt. Everyone owns Carhartts in Indiana. Like, people that aren't familiar with the Midwest and like farm towns, it's what they wear. It's like you go to Farm and Fleet and they've got an entire section of Carhartts. It's a very, very popular brand. Okay. Like, it's just, it's one of those things that farmers wear and people in rural areas wear, along with blue jeans and boots. And I'd hazard to guess a lot of people own 40 millimeter weapons. I'd hazard to guess that a lot of people hunt and own knives. You know, they just didn't find anything that I found to be like a smoking gun in terms of, now, does that mean that when they forensically test it, that they didn't find something? I don't know. I mean, maybe. I mean, if we're hoping for justice and we hope that they have the right guy, then yes, of course, we hope that they found something. Based on what I saw in the Franks, it doesn't sound like it. You know, it does not sound like they've made any of those connections. We know that they did not find anything on his electronics. I say it on repeat. And I'm telling you, the defense attorneys aren't lying about it. They're not lying about it. So, like, in terms of what they're saying was in the discovery, it's like, is it, of course, subject to their interpretation? Obviously. But just like law enforcement, they interpret the evidence in one way, and that's how they land on Rick Allen. They interpret him as giving a statement that he was on the bridge around the time that they think the girls went missing, as him being bridge guy. That's their interpretation of it. You know, now there's obviously time frame issues. Like Allen's first statement, he's gone by the time the girls are dropped off. Like, Kelsey drops him off at 1:47 in the afternoon. Rick Allen says he left at 1:30. So, you know, I mean, there's issues there, like, which is what causes trials. Like, again, people, there's a whole group of people out there that are just convinced that Rick Allen is pleading out. And I've got news for them. He's never pleading out. Like this case,
based on your opinion,
on my opinion, of course.
Right.
And just in terms of when I'm looking at just the reasonable doubt that exists as to the facts that we know, there's no way. Now, if they've got something, and I am absolutely including the confessions. I'm including that. I've not forgotten that he's made these alleged confessions, and they've been acknowledged.
And I've said, and I'll say again, as far as I'm concerned, until we hear them, they don't exist. Like, I'm not taking them into
Right.
account as an actual confession until I hear it. Maybe it is. Maybe it is.
Right. I mean, what you'd want to hear are some facts. Like you don't like what you don't want to hear is him at the end of a phone call. Oh yeah, by the way, I killed the girls. Like, you know what I mean? Like, you want to hear him going on, like, if it's a confession, like a 10-minute thing. I can't believe I did it. I don't know why I was, that kind of shit. Like, it just goes to what you're saying. We just need to hear it so we know the context of all of them. Apparently, it happened multiple times to Kathy and to his mother. So,
So we'll see.
so
But
we
I
need
did,
to-
I mean, I did just want to restate the motion in Lemonade that dealt with the ballistics, as Ariel points out. That to me is why I was like up in arms, like, wait a minute. No. That is not something, absolutely positively not something that can get ruled on without, considering the experts' opinions. So, but I don't know what was in the motion per se. And that's why I'm saying they should file a motion to reconsider because they wanted to present expert, testimony that speaks to, just like she said, all those rules of evidence that deal with whether, it's prejudicial, more prejudicial than probative, what the expert's position is. I don't know, that's crazy. Like that one, you can't, like a Frank's motion's different because even though it's typically you're going to go to a hearing, it's on the face of the documents. It's on the four corners of the documents. So in theory, yeah, no big deal. But that motion in Lemonade that they needed to set for hearing and then give them the opportunity to present whatever they wanted to present.
Yeah, for sure. I mean, with the Franks, theoretically, she could have looked at the statements from the witnesses, right? And looked at what Liggett had in the PCA or in his affidavit and compared and contrasted. Like, I mean, she could have.
That's weird, though. That's not usual.
I know it's not. None of it's usual. That's the whole point. None of it. It's like that's why we have the Star Wars Empire Strikes Back.
No, that's why.
Because this whole case to me is like fantastical in terms of just how out there it is like a science fiction movie. It's like I can't believe what's going on, and it's everybody involved. Like, because at the end of the day, you've got two victims' families, and then you've got this defendant who's sitting there who may or may not be guilty. I don't know. But like this process that's swirling around him is horrifying. And he is incommunicado for the most part. You know what I mean? It's like, if you can imagine for a moment that he's innocent, like if you can put your mind into that place and just imagine putting yourself in that position and then having all of this shit going on around you, with really no one to explain it to you, like just like having no idea what is going on. Like, this is just not a typical type of situation. I mean, Gull is removing his lawyers without even having them in the courtroom. She came out and we had the unexpected turn of events speech, and Rick Allen was nowhere to be found. It's just like the people that we're concerned about at this point are not the players in the game. It's the families and the defendant, because they are really what matter. And at this juncture, exactly, it's the defendant. Like, that's what we're concerned with at this moment in time, is the constitutional rights of the defendant.
So let me ask you this. What is this about the opinion that the judge had about the exhibits A and B attached to the motion being relevant and admissible? What does that speak to?
I don't know if Yellow Jacket's saying that it was a typo in terms of defendant's exhibits. I don't know if she means like it should have said the state's exhibits. I'm not exactly sure. Yellow Jacket, flesh that out. Give us more on that, Yellow Jacket, because I don't know what you're getting at. I don't know which. There's been multiple motions.
She's quoting the judge's ruling. I'm assuming.
I understand, but I'm assuming the denial in the order, but she denied 3 different motions. So I just don't know which one. I'm assuming that she's talking about the bullet, the unspent casing. That's what I'm assuming.
Okay, that would make sense. But yeah. That's so. And I just also want to say that there are occasions where we go into court and the judge has said, like, we filed a motion, like you said, to whatever the case may be, and the judge is like, I've reviewed everything. I've really, considered it. I actually even looked at blah, blah, blah. If the judge were to say something like that, where then we're just like, some little brief argument outside the papers, and then, and then she rules anyway. But
yeah, I don't know.
This is something that you've been
Candace, we'll get to you. We'll get to this because we're covering all that.
A big topic of conversation around here. So
yeah, like 100%. So, but I just want to lead everybody into it because then we have her denials. We then have like shortly thereafter. And again, this is all through the lens of, we don't have the Supreme Court opinion yet. We don't know what the reasoning was for reinstating them or for not like pulling Gull from the case. We don't know any of it because it's still not out, so I think is a reactionary move. We get Rozzi and Baldwin filing their motion to DQ. And then as a reactionary move to that, we get McCleland filing his motion for contempt same day. Because like anybody who thinks that McCleland drafted that up like in a day's time, no. That thing he was sitting on it. And I think that initially the plan for everybody until Gull started this train rolling with her denials was, let's wait, let's see what the Supreme Court says, and then we'll start doing our filings. Once she did that, she started the train in motion because we knew that there was this situation where there's a motion to DQ her that was filed. Would you guys rather see Allison dip off screen like that to vape or just vape? Like, because that's ridiculous. Just stay on screen.
Nobody knew what I was doing.
What? But you're going to continually do it. So
but
just stay on.
I
I don't think people are being all judgy and care, to be honest with you. And if they are, too bad. So as far as because I want you to concentrate on what I'm trying to say. The one thing that we know is that Rozzi on October 25th, I think the day was when he filed after the 19th comes and goes. He says he's going to file something in writing in terms of him withdrawing from the case. And instead he files his verification that he's remaining counsel for Rick Allen. And he files the motion to DQ her. Okay. So that was pending. So I think what happens is that as a result of them filing their pro bono appearances, that at that point she was able to say, all right, I am taking your filings on the 25th as non-filings. Because you have acknowledged now by way of you filing your pro bono appearance that you were not the attorney of record, Brad, at the time that you filed those. So, because it has the same effect. If he had filed those on the 25th, she can't rule on these 3 motions. Now, that doesn't mean that she can't rule on them down the road and still deny them. But I'm just trying to figure out the thinking here. You know what I mean? Because that existed in the world. Brad had already filed a motion to DQ. They beefed it up. And so then they filed that thing yesterday. I spent 2 hours reading it because it was voluminous. Richard Allen's affidavit was, and they're bringing the receipts. You know what I'm saying? They're bringing their receipts. And at that point, they're laying out their case that she's biased, and it's a nuanced argument, because you have to argue bias in a nuanced type of way, because other than the fact that she said on the record multiple times that she felt that they were grossly negligent in the representation and gross incompetence. I think that those two phrases alone, without anything else being there, are enough to show bias of a judge. Like whether it just be on this case, whether it be in general that she feels that they're incompetent or grossly negligent, doesn't really matter. There is no unringing that bell. It can't be undone. It can't be unsaid. It's there. And when the public has to look at it in terms of objectivity and in terms of us having faith in the system, is Darren off screen like yapping at you and making jokes?
Oh, I was reading someone's comment. What happens when you smoke wheat? Like people are still focused on that wheat argument in the Supreme Court.
Okay. Because I thought our producer's finally in town from New Orleans. So you guys like Allie's new setup? It's pretty sweet. It's much better than
I'm in the basement.
And you sound way better too. So you got
this mic.
You got your full-blown mic. You got the big girl, the big boy moves, big girl moves, as it were, getting all set up.
And I got this seat like up high, so I look a little taller.
Yeah, you look gorgeous as always. All right, so let's dig into it. So we get the Allen thing. I had told people that I wanted to be able to talk about the motion to DQ yesterday because I did truncate that. I cut it short because I had somebody ringing my doorbell maniacally. It was somebody I was expecting, but they were 20 minutes early. That's why I was trying to get through it. So I did kind of stiff y'all on being able to answer any questions. And I forgot to thank all of those that were kind enough to either join with a membership or subscribe or gift memberships or, obviously give us super stickers. Thank you for that yesterday. I saw it and I'm very appreciative. And
so you're saying before we dig into the next piece, you want to know if people have questions about the motion to disqualify?
Yeah, I'd like to know if there's any folks out there that like felt like they got short shifted. And I had a lot of my friends, fellow creators, like talking about it. Like Teresa was on, and she's phenomenal. Gisela was on with the Grizzlies. She's phenomenal. So like there were just a lot of creators out there that were covering it. And I know that we kind of all jump back and forth. Our members, a lot of them are members with, both of those two groups too. So, but if there's any out there that do have questions on that, otherwise I think what we will do is that we will just move in to Nick's filing. All right. And the first thing that I want to do, I'm going to bring up the actual statute. All right. So this is the statute they're coming under. And now Nick is coming under the statute for indirect contempt of court. Now, indirect means that it happened outside of court as opposed to in court. Direct contempt of court is when somebody acts a fool in the courtroom and the judge bangs the gavel and holds them in contempt, whether it be a witness, whether it be a lawyer, whether it be a defendant, anybody that acts a fool in court, that's direct civil contempt. Now, indirect civil contempt is when a court order is issued. Okay. And we have a couple that are at issue here, and we're going to look through both of those as well. I'm going to pull those up that McCleland is claiming that they violated. Now let's just go through exactly what it says. So now he cites at the beginning of his particular motion 3447 3-5 letter D. But I want to go through all of them.
Why?
Because it's important. Well, I at least want to go through section 1. Okay. So it explains what the standard is. So section 1, which is 47 3-1, is a person who is guilty of any willful disobedience. That is the key word in this entire sentence. Okay. Willful disobedience of any process or any order lawfully issued. So it has to be willful. That means that the participant understands that there's either an order or a process in place, then that person is giving the big bafangu to the judge and saying, you know what, I'm violating the order. I don't care about the order. It's got to be willful. Okay. And so it's the full sentence is willful disobedience of any process or any order lawfully issued, 1, by any court of record or by the proper officer of the court, 2, under the authority of law or the direction of the court, and 3, after the process of or order has been served upon the persons, is guilty of an indirect contempt of the court that is issued the process or order. Okay.
So that part, we have all 3. It's just that first line that you read that's in question, which is obviously the most important.
Which is, was it willful? Was any of what he is going to talk about, which we're going to go through in here, was it willful? So this is what he cited when
that's
we get
just
to
the issuance of the rule.
Correct.
Step 1.
Right. So he did it pursuant to this. So when you guys were looking through, and I'm just going to pull it up now, that's what he cites to, that particular rule in terms of him serving it upon the 2 defendants. All right. All right. Let's see. We're going to go. All right. Okay. Hold on. Let me pull this down. Okay. I'm going to close this guy. Oh, okay. We got these guys. All right. So I'm going to go here. Now, what we'll pull up first, I want to go to his actual motion. All right. Now, I also have pulled up, and we'll go through, I've got the gag order. I want to review that. I've also pulled up the protective order.
That's I know the one I think that is the most, that's the most relevant to what we're talking about right now.
I agree. But like a lot of people out there confuse gag orders and protective orders.
Which really is why I'm saying we can just focus on the protective order because that's the one at play.
Well, I think both are in play a little bit, but
yeah, that's true.
Let's check it out.
He did quote both of them.
He does, definitely.
Yeah.
All right. So here we go. We got the order. And you're probably, you had to have been thrilled that you didn't have to sit through 2 hours of me reading yesterday because it was a lot. Like it would have been a lot of eye rolling, a lot of like, let's wrap it up. Like, do you have to read that paragraph? People don't want to hear this shit. So this is substantially shorter. It's 6 pages. We're going to read through it, but we're going to stop as we're going. Okay. We're going to break it up into more palatable bites. All right. So comes now. Do you want to read any of this? I always like hog the reading.
I love when you hog the reading.
Okay. All right. All right. Comes now the state of Indiana by prosecuting attorney Nick McCleland and brings to the court's attention as an officer of the court verified information of contemptuous conduct by defense counsels Brad Rozzi and Andrew Baldwin pursuant to, and there's that rule that I was talking about, 344735D. The state,
like Bob was saying, I'm so sorry, only deals with the way they serve it. It has nothing to do with what the actual document is alleging.
Correct. The state would ask the court to order Brad Rozzi and Andrew Baldwin to appear before this court and show cause if there be any reason why they should not be held in indirect contempt for violation of this court's orders. The state would ask the court to consider the following information. 1, so he's going to go through the factual background here that Rozzi and Baldwin were appointed to this by this court to represent the defendant herein as PDs, public defenders, on November 14th, 2022. Paragraph 2, that a hearing was held on November 22nd, 2022 to resolve preliminary matters the same day that the state of Indiana filed a motion for an order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication commonly referred to as a gag order. Now, do you want me to pull up the gag? Should we just pull it up real quick?
Sure. You know what? When you get to the, okay. I was going to say
short. It's short. Right. So, and I think it's helpful for people to look at it. All right. So this is the gag. All right. So this is the order that was entered on the court's motion in response to defendant's updated press release The court issues an order granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, family members from disseminating information or releasing any extrajudicial statements by means of public communication in whole, pending hearing, which the court has recently scheduled for January 13th, 2023 at 10 a.m. in the Carroll Circuit Court. Counsel for the state of Indiana and the defendant, as well as their professional staff and other personnel, law enforcement officials, court personnel, coroner, and all family members are prohibited from commenting on this case to the public and to the media, directly or indirectly, by themselves or through an intermediary in any form, including any social media platforms. Counsel are reminded that they're required to conform to the Indiana rules of court rules of professional conduct, specifically Rule 3.6 trial publicity in its entirety, and Rule 3.8 special responsibilities of a prosecutor in its entirety. So that's it. Like, that's basically violations of the order punishable as contempt of court and subject the violator to a fine and or hard time, baby, incarceration.
So right. I do want to note the trial publicity rule does have a loophole, which, if I'm going to be able to read this here.
Like, as we sit here right now, while you're looking that up, I don't know how Gull has jurisdiction over family members to stop them from talking to the press. I've never heard of anything like that, except in the Idaho 4 case. The judge there did the same thing, basically shut the families down from talking.
I still don't think she has any legal jurisdiction over them. So the rule generally just says you're not supposed to speak in a criminal case. The identity and residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of the arrest, the identity of the investigating and arresting officers or agencies, length of their investigation. So those are the things you are allowed to speak on.
Which rule was that? Was that 3.6 or 3.8? That was 3.6.
It's the trial publicity rule. I don't know.
Okay, so that was rule 3.6. Okay.
So, the part that I wanted to mention is notwithstanding paragraph A, which I didn't actually read. I wish I could start this over again. But a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial, out of court, statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Sorry, guys, I need glasses with this at this point. In the matter. And then it says what they can do, which is what I read before. Like, if you're just going to say the certain things that the state can do, and the defense attorneys can state the claim, offense, or defense involved, and accept, when prohibited by law, the identity of the persons involved. So you've got that. Again, you can say, notwithstanding paragraph A, a lawyer may state the claim, offense, or defense involved, and except when prohibited by law, the identity of the persons involved, which would mean like you're dealing with minors and things of that nature. 2, the information contained in a public record. 3, that an investigation of a matter is in progress. 4, the scheduling of results of any step in the investigation. 5, a request for assistance in obtaining evidence and information necessary thereto. 6, a warning of danger concerning behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or the public interest. So then the other ones I read earlier were the other things you can do, like that the state usually does. So then what I call the loophole here is, notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited in such information as is necessary to mitigate the recent adverse publicity.
So that's the safe harbor rule. That's basically essentially saying that in order to even the playing field, if the state has been putting a bunch of shit out there, that we as defense attorneys have the ability, and the state, vice versa, it goes both ways, that we have the ability to be able, that there's a safe harbor, meaning that we can't fall subject to that ethical, that rule, because there's a safe harbor to allow us to even the playing field by either, coming out and saying what everything that guy just said is bullshit, and we've even the playing field, and like we had that issue in Garcia. We felt that they had been trying our client in the press with leaks from the prosecution and or law enforcement and or both. And, it was the same type of gamesmanship that's going on here from everybody. Everybody, when the memo came out, a vast majority of people are like, oh, this is them just trying to get their defense out there to the public, which is absolutely true. I think that there's no denying that is part and parcel of what that was, and there were people that were talking about that they're just trying to throw like a smoke screen up there with this Odinism stuff, that's completely ridiculous. It's modern day satanic panic, blah, 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 and so that's out there. And then, in my estimation, this is exactly what the memo was. It's a much shorter version by Nick McCleland. What we're going to go through here is of what the memo was. This is now McCleland coming back, striking back, and saying, okay, well, you know what? You did it. Now I'm going to do it. We heard about Gull's 5 points that she felt was, were at issue. And now I'm going to flesh them out for you. Now I want to put them out there for the world to see, so, and this is what we're going to deal with. All right. So let's keep going through it. All right. So paragraph 3, that the court took the state's motion under advisement, but in an in-chambers conference, defense counsels Brad Rozzi and Andrew Baldwin refused to agree to the state's motion, stating that an order, i.e. a gag order, was unnecessary because they had no intentions of discussing the case in public. Okay. So you've got that. It's like, so this is his thing. So he's saying that they're in chambers, that Gull's like, well, Nick filed this thing, he wants to gag the case. And, and then Nick's claiming that Brad and Andy are like, oh, don't worry about it. We're not going to talk, but we're not going to try this case in the public. Like, we're not going to try. Like, I do remember seeing a quote from Andy saying that, it's not our intent. We're not going to try this case in the public. Okay. So then.
Well, that's different than what he says. He says they're not going to talk about it. They're not going to discuss it in public, but let's take it to mean discuss it with the public instead of in public. But if they said that as opposed to what you just said, well, then they were a little disingenuous with their next steps.
All right. So paragraph 4, then on December 1st, 2022, the defense put out a press release that included extrajudicial statements by means of public communication that commented on the case to the public and to the media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence that they believe proves the defendant innocent or proves the defendant's innocence. The information released would have been in direct violation of the gag order that the defense would not agree to, and which the defense stated was unnecessary because they were not going to discuss the case in public or the media. The press release is herein attached as Exhibit 1. All right. Now I pulled it up. Have you ever seen this thing? This press release?
I just read it tonight.
Oh,
I
you
did
did?
see it initially, but I refreshed my recollection with it.
Right. So he basically, I mean, this is, and look, my position when this came out, like not necessarily knowing what had taken place in chambers, was I had no problem with it because we live in a world in which all of us are typically only given the state's theory of the case for the years pending trial. Like that is the world we live in. The state and law enforcement's theory is put out, whether it be in a PCA or whether it's released to the media. And that is the story. It's one side of the story. It's one theory that is out there for 2 years. That's why everyone thinks everyone's guilty, because you're never hearing the other side of it until trial. And it just sits there and it ruminates and it percolates, and it's a very unbalanced act in terms of that presumption of innocence that kind of is a constitutional thing. And so I had no problem. I actually loved this move. I was like, oh, for once. I remember when this thing came out, I was like fist pumping. I was like, yeah, go defense bar. I'm like, finally, somebody like put out the defense's theory of the case. So now the world has two things to look at. They can look at what the state's theory is, and they can look at what the defense's theory is, and then they can make their decision. At least they have a choice. At least they have a full picture. So I want to go through this thing. All right. It's short. So the first thing that they say, I'm going to skip the bold. We do not want to try this case in the media. That's the first thing they say. And we intend to adhere to the Indiana rules of professional conduct that provide guidance on pretrial publicity. However, the police, and this is going to fall right into what you were talking about, like the pretrial publicity thing. However, the police and prosecutor's office have conducted many press conferences over the 5+ years of this investigation and following our client's arrest. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct to make a few comments concerning the probable cause affidavit and Rick's innocence. So they're going right for the safe harbor. Like they've got their little ship and they're cruising it in right into the safe harbor, right?
And
so
that's when Bob points that out, it is literally for that reason. So if this were to end up at whatever the equivalent to the attorney disciplinary commission is in whichever state, they see right there that this lawyer has considered the rules and believes that they are falling within the safe harbor. So that language was intentionally, placed there for that reason, like Bob said, to steer their little boat right into the safe harbor. It was cute. I want to see you steer again.
You'll have to watch it on replay, crew. All right. So Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. He is innocent and completely confused as to why he's been charged with these crimes. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help any way that he could. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. Now, when you think about the fact that, as Susan was saying the other night, that law enforcement was 100% relying on the fact that when Bridge Guy photo came out and the little sound clip down the hill came out, that somebody was going to come forward and say, yeah, I think that might be my uncle. I think that might be my brother. I think that might be my husband. I think that might be my neighbor. I think that might be my buddy. Like they thought it was going to happen. So
I still think it would have if it was. That doesn't mean that Richard Allen's not involved. I just have trouble believing he's the
bridge guy. I don't know.
person in this, right?
Yeah, I don't know. All right, so like that's a strong statement, and I don't think that it's not true. I've been saying that all along. People are always like, he admitted he was on the bridge, and you and I always get into that little debate. I say, quit using the word admitted. He volunteered that he was on the bridge.
No, there was a more a different word that they were using, like admission, because he did admit. But when you say the word, it was an admission, it implies some sort of fault.
All right, I'm gonna have to call Darren in here because admission and admit are the same word. I mean, it's just a different form of the exact same word. An admission is to admit something.
I know.
But admission. All right. So at any rate, my position is that he volunteered information. He didn't come in. Like, admissions is like when you're admitting to doing something wrong. It gives that connotation.
That's what I'm saying. The word admission has that connotation where the word
is admit. I admitted it. Did you admit? No. I want you to admit. When Brett was screaming at me on our live, he said, admit it. Admit it. The leak was horrible. So he was trying to get me to make an admission. All right. So Rick volunteered to meet with a conservation officer outside of the local grocery store to offer up details of his trip to the trail on the day in question. Rick tried to assist with the investigation and told police that he did not recall seeing 3 younger girls on the trail that day. That he did recall seeing three younger girls on the trail that day. His contact with the girls was brief and of little significance. Rick does not recall if this interaction with the conservation officer was tape recorded, but believes that the conservation officer scribbled notes on a notepad as Rick spoke to him. And that's Dan Doolin they're talking about. All right. So after Rick shared his information with law enforcement officials, he went back to his job at the local CVS and didn't hear from police for more than 5 years. Now, a lot of people are like, wonder out loud that like in 2019, in 2021, when law enforcement, they have a presser and they're asking for people to come and talk, like, why didn't Rick Allen go and talk to them again? It's like, about what? Like, what is he going to say? Like, why is it like, if I'm Rick Allen, I'm assuming 2 things. I'm assuming, one, that this guy who was scribbling his notes, that I'm in their file. They know I exist. I'm not a specter. I didn't ghost. I didn't move out of Delphi. I'm still working at the CVS. And if you've never been to Delphi, it's one of those close your eyes and you miss the towns. It's like, it's very, very small. Like, it's a very, very small town. The CVS is like, frankly, the biggest business in the town, So like, I just don't know what people's expectation, or that they're assigning some kind of guilt that he didn't come back and talk to them for what? Like, I just, if I'm Rick Allen and I didn't murder 2 young girls, like, and I've already made a statement, I'm not even thinking like, why do I need to go back to them? Like, if they want to talk to me, they know where I live. I gave them my address. They have my phone number. They know where I work. So I've never gotten that argument. It's always like rang very hollow with me. So the next time that Rick heard from the cops was in October of 22. This was approximately 2 weeks before a contested sheriff's election, and within days of the federal lawsuit filed against the Carroll County Sheriff's Office by its former second in command, Mike Thomas. All right. So they throw it out there. They're already like right there. They're making that clear assumption that Tony Liggett is in this battle for the sheriff's election, for the sheriff to be elected the sheriff of Carroll County. And that, what would be really helpful in terms of getting elected as sheriff? Are you paying attention? What are you doing?
Sorry, I was responding to someone's comment saying that could she be blocked, just letting her know I don't see how or why it would be something that we did on our end. She's saying she can't post chats. So I apologize.
Is she a member? She has to be a member for 5 minutes.
Oh, there you go. You have to be a member for 5 minutes.
Yeah, we want you all to be, or no, not a subscriber, not even a member. You don't even have to be a member. You just have to subscribe to the channel.
But so she's also a new member. so she didn't
Yeah,
get it.
they're like, I don't know. Mods, can you deal with that? Let our mods deal with it. We have tons of mods in here. They'll deal with that. We're not trying to block people out. I mean, y'all were pretty rough on Susan, some of you, so I think we were trying to, tamper that down. Like, we're big on discourse here. We're never trying to keep anybody with opposite views. We're not going to shut them down. If you're coming
Right,
in,
I understood that she has to be, conscious of how the family is going to feel, because she knows if she's on it, they're going to watch it. So I kind of did see that and appreciate that, and tried to sort of keep the way I approached it,
I know. Well, everyone had you pegged as the hero of the day, because I was like,
well, I was going to come at her, just
well,
not.
I was going to come at her too, because believe me, I knew what Susan's position was. I mean, I was talking about the book. I mean, she had endeared herself to both law enforcement and the family. She's going to be sensitive in terms of questions that are going to skew her as biased. Or
Well, I wouldn't give a shit
to
about skewing her as biased for the purposes of the police, but I did want to be. I just wanted the family not to feel like, I don't know. I was just keeping it in mind. So
right, like my entire point of having that is I hoped that the family was going to watch. I really did, and I wanted them to hear what we had to say, because I don't know what they hear and what they don't hear. I don't know what they believe or they don't believe. I've never had contact with the families. I respect their privacy. I'm not trying to reach out to them. If they know where we're at. If they ever wanted to ask us a question, they could very easily do it. So in the sense that they haven't done that, I'm assuming that they don't want to talk to us. However, I just know how law enforcement, and I'm not talking about in this case, I'm just talking about generally, that victims' families rely completely on what they are told by law enforcement and the prosecution, that we have the right guy. Don't worry about it. I don't give a shit what anybody's saying out there. I don't give a shit what that memo says. We've got the right guy. Trust us. Don't let, and it's like, I just try to think of it, which is impossible. Like, if one of our 4 kids had gone through the nightmare that they're going through, like, what I would be thinking if I was on the sidelines, gagged by a court, and
well,
like,
that wouldn't happen.
Right. And
Especially
seeing all
if
this
we had
shit
issues with whether or not they had the right person. I mean, I don't even want to go there, but just anything that if we knew. But I sidetracked you from reading, so go on.
Yeah. All right. Okay. So we're talking about, they're basically intimating that Liggett made the arrest in order to get elected for sheriff. That's the bottom line. Okay. So in the lawsuit, Thomas claims that Thomas had made a suggestion and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. Furthermore, Thomas claims that he was also removed from other high-profile cases. Rick was ultimately arrested on or about October 28, 2022. In the 5 years since Rick volunteered, see, they're very careful to use the word volunteered. They don't say when Rick admitted to being on the trail. When Rick volunteered to provide information to the police, Rick did not get rid of his vehicle or his guns. He did not throw out his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued his normal routine. I'm sorry, but that is an incredibly compelling thing. In a town that small, when that video comes out, if you're the guy, I'm gone, Joe. It's like, if my wife's asking me, well, why? Why are we? Because we got to go. like you can come with me, or I'm leaving, but we got to go. I got to go. You know what I mean? It's like there's no world in which I can fathom that being the case where he's committed these atrocities and is just going to go about his normal business. Like in that town, like he was in a very, I keep trying to like build the picture of just how small and quaint Delphi is.
Just
And
how small and quaint is it, babe?
It's very small and it's very quaint. And he's in a very public position in CVS. It's like we go to the same gas station and have been for the last 15 years. I know every single person that works in there. I chat with them every single time I go in there. Like
you know
I've
what?
been for years.
I saw a quick video of them that was even a partially looked like them. I might not call the police right away, but you can be guaranteed. I'd be like, you know what?
That looks like that sucker that works at the gas station.
Yeah.
Yeah, you know, the late night dude, the guy who's always bitching about that they have him working 17 hours. That guy, it kind of looks like, yeah, totally. You're like, people would be having that conversation. I don't know. All right. Okay. Probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussions regarding the veracity, which means truth, for those of you that don't know what the word veracity means, of this evidence. You can't assume that everybody knows what veracity is until more discovery is received. But it is safe to say that the discipline of tool mark identifications, ballistics, is anything but science. The entire discipline has been under attack in courtrooms across the country as being unreliable and lacking any scientific validity.
Facts.
We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet.
And then for anyone who doesn't know, that is precisely one of the motions that the judge just denied, the one that got me more up in arms, as or whatever, however Bob put it, that the judge did without any sort of actual hearing.
Yes. So it got flushed. It got flushed down the toilet. It's done. Okay. So on Rick's, on Rick's behalf, we argued to have the PCA unsealed. Rick has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all which will be vetted by our team. Although it is a burden of the prosecution to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Rick's innocence. We appreciate those that have reached out to support his cause. Prosecutor mentioned at the last hearing his belief that others may have been involved in the killings, yet there was no mention in the PCA about a second suspect involved in the killings. The defense is confused by such discrepancies in the investigation and will be in a better position to respond as more discovery is received. Rick Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or Smart Car that was described by the witnesses. It seems that the CCSD is trying to bend facts to fit their narrative. At this point in time, we have received very limited information about this case and look forward to having something more to view than that which was offered up in this sparse PCA. Moving forward is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. To the extent that we continue to discover information that points to Rick's innocence, we will offer up this information to the public. They warned you about the memo right there. So long as we are not prohibited from doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. Brad Rozzi, Andy Baldwin. All right, so there you go. So there's the press release. So this is the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing an adjudicated proceeding in this matter. What's a PCA do? Like that's my whole point. That whole sentence, that the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing an adjudicated proceeding in this matter. What does a PCA do?
I know, but I do think that the rule, I'm going to try to pull it up again. might have some presumptive things that you don't say, but maybe not.
All right. Well, while you're looking that up, I'm going to keep reading. All right. That the court entered an order on December 2nd, 2022, granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, blah, 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 from disseminating information or releasing any extrajudicial statements by means of public communication in whole without a hearing. The order directed the attorneys not to comment on this case. Not to comment on this case. Where the hell was I? I was starting to wonder if I just read that. Not to comment on this case to the public or to the media directly or indirectly by themselves or through an intermediary in any form. The court reminded counsel at that time that they were bound by the rules of professional conduct 3.6, which Allie's been reading to you. This order is commonly referred to as a gag order, which we just went through. The court commented that this order was put out in response to the press release by defense counsels Brad Rozzi and Admiral Baldwin. All right. So at this point, I hope everybody's clear. There's a difference between a protective order and a gag. A gag stops you from talking to the press, okay, and the public. Like you can't, like it's like I always look at it as just the press. A gag does not stop Andrew Baldwin and Brad Rozzi from talking to other people that they consider confidants about potential trial strategy. That is not what a gag is. It's not what it is. But when we get to the protective order, we're going to discuss it again, because if there's any kind of place for that to fit, it would have been with the protective order, but we're not quite there yet. All right. So did you have anything you want to read, Bay?
No, there's nothing presumptive that's in the statute. But, you know, the unfortunate fact is, and it's honestly something that I'm like arguing sort of implicitly in this post-conviction petition, because for those of you who don't know, Chicago's justice system, you know, in recent years it's been called the culture of corruption that's been exposed, that the police were, you know, beating people and forcing confessions and, you know, all the things like that you see that happened in Baltimore, you know. And there are a lot of ASAs who were absolutely positively facilitating this, maybe without the same knowledge or, you know, in any event, my point being, like, whenever the prosecution speaks, it's all right. Like when they have these press releases and they release the PCAs to the public, it's all right. But whenever we fire back, it's always an issue, as it was in our case, the one that Bob keeps referring to, where the publicity was, you know, way more prejudicial, you know, and it's still like, when do we get to use this safe harbor, and why is it there if we never get to use it? But
Right.
yeah, I mean, I think everything that the state says absolutely positively, what did he say, presumptively violates the trial publicity rule.
Right.
But he thinks it's okay because it's him. You know what? The days of him having automatic credibility and the police having automatic credibility have long passed.
Over. Thank God.
They should be, but the courts.
I mean, people still want to trust the cops, you know, and like we all want to. It's like in a perfect world, we want to be able to trust officer friendly, you know, but like there's plenty of officer unfriendlies out there. There's plenty of officers that are just trying to get collars and get arrests and close cases in order to move their careers along. Like every profession, there's shitbirds. There's shitbird defense attorneys. There's shitbird prosecutors. There's shitbird cops, shitbird teachers, shitbird preachers. Judges. There's shitbirds of everything. You know what I mean? It's like, but the problem with cops is when you're a shitbird, it has a massive effect on people because you have a hell of a lot of power. With that gun and that badge, once you place somebody in arrest and you've got the ability to mess with evidence in order to make somebody, and like, dude, I can't even, like, I don't even want to start on the whole AI thing.
You know what would be fun?
That shit is freaking me out, man.
You know what would be fun
is that can affect the criminal process. Like people will be able to come up with like full state, like they can pull my voice off of one of our lives with AI and have me literally like confessing to a crime. Like, and like, how's somebody going to know? It's authentic. Like it's so scary, the probabilities and possibilities of what's going to happen with AI, that it's like, it's hard for me to fathom. But that's a whole different thing. I digress.
But I was starting to say, what would be funny would be if someone started a podcast, the former prosecutors, and like they just divulged like all their like secrets and, you know, admit to certain things that happen as a matter of course and systemic issues. And I want to see that happen. If there are any former prosecutors out there who are willing to speak openly and honestly about some of the flaws that you see within the whichever state's attorney or county attorney or whatever government office that you were once in, you should start a podcast or a YouTube. Thank you.
Yeah, no, I agree. That would be dope. That would be super dope. Because it's like there's just trade secrets that you want to know, you know, but
There's
like
apparently a book. So I was, when I was doing my research on this, and I had come up with like this theory that I've been talking about, that I think that the cops and this state's attorneys were doing on purpose. Somebody who was a former prosecutor who wrote a book that was like the secrets, and he did that. Apparently, I haven't read the thing, but apparently he comes out with it. He like says what they're kind of coached to do and how they sort of, anyway, go on.
Okay. All right. That sometime in December of 2022, defense counsel Andrew Baldwin violated the court's gag order by sending an email to Brandon Woodhouse containing an outline of discovery. That's the discovery index for the evidence, including the names of juvenile witnesses. Brandon Woodhouse is not an attorney on this case and is not involved in this case in any capacity. Okay, that's not a violation of the gag order. Like that was an email that was sent in error. Like I hate to admit it, but me being completely like just like a basically like a Luddite, like a tech, like caveman. You know, I mean, I probably overstate
Or was
that.
it, as Larry David says, the accidental? Well, that in that case was a text, but the accidental email on purpose.
Well, that's what he'd have to be implying, that it was the
Yeah.
accidental on purpose. What was it? The accidental
email on purpose.
Yeah.
In the Larry David episode, it was the accidental text on purpose, but to
right. And like I've sent them, because like when you go into your email, it like always auto populates. Like I rely on it all the time. Like if I have multiple Brads, or if I have multiple, like anybody with a relatively common name, anybody that I've emailed in the last, however, that it's going to pop up, and it's typically, it's going to go in order of like the most recent email to that person. Like that's the one auto populate.
Let's get to the point, because we're an hour 15 in and we haven't even started talking about all the juicy stuff. No, I know they do, but I want to talk about how it's bullshit they're going through his, all right. Work. I want to get to all the stuff.
I hear you. All right. That further, the defendants counsel Brad Rozzi and Andrew Baldwin failed to notify the court or the state of the dissemination of information in this case to an unauthorized recipient, and intentionally withheld that information from the court and the state by asking Brandon Woodhouse to delete the email. Fair. I would 100% be like, yo, dude, I just and Woodhouse is a former client of Baldwin's. I'd be like, yo, man, I accidentally just sent you an email. Could you do me a solid and just delete it?
And I can guarantee you I wouldn't be calling anyone, letting them know that I just accidentally did that.
Wait, you wouldn't? Oh, you mean the state?
Right. Once it goes public, if it went public, then I might be like, hey guys, I'm sorry, this was me. But
right. And it was the index. It's like a list.
It's
like,
of no
it's of no real consequence. Like when he has to rely on that it had witnesses' names is like the strongest thing that he could put in there. Big deal. I mean, yeah, in a perfect world, you don't want to be sending shit to the wrong people, obviously. But in terms of the scope of things, you know, like I just don't consider that a leak. I'm sorry. I just don't.
Yes, and anything that the lawyers create, especially anything that involves any part of their strategy or interpretation or notes about the evidence or anything else, is attorney work product that no one else should ever see,
Uh,
especially law enforcement and the prosecution. In such a case, they should put a special prosecutor in place who uses his own investigative team and
Wait, are you
investigates.
jumping way ahead?
I'm
Like
just saying,
you're jumping to the end game, girl. Like, is that what you're doing?
well,
Like
someone
that's
stuck up the question there, so I just wanted to clear it up because I don't know if it's a battle that's going on in the comments that we're missing.
hey, you're frozen, and I don't know why you shouldn't
So are
be.
you on my side.
Really?
Uh-huh.
Oh, not this again.
But at least people can hear us. Can you hear us,
Yeah.
Darren?
I want to see if we're frozen on screen. Oh, so annoying. It's just so annoying. I think we're moving on screen. I don't know. Are we moving for y'all? Because I don't care if we're frozen for each other. All right. I'm gonna keep reading. Yeah, it's weird. You're frozen for me. It's like move on screen so I can see if you're moving. I don't know. Allie is frozen. It's weird. Like, I don't know why you're frozen. All right. You shouldn't be frozen. Like I put a big like extender right there. Do you see it? Can you hear me? Oh, she's muted too. All right. Maybe they're trying to deal with something down there. It's like a never ending with it. And she got a brand new computer. So it's not the computer, it's our internet. Like I've done everything we can. We live in a remote area. So it kind of is what it is. We're trying to get it fixed out before the morning drop though, before that starts. Cause like, I don't want it running like this. All right. So, that further counsels Bradley, Rozzi, and Baldwin failed to notify the court of the state of the dissemination of the information in this case to an unauthorized recipient, and intentionally withheld that information from the court and the state by asking Brandon Woodhouse to delete the email. And then that this leak of information was not discovered until the state uncovered it on Brandon Woodhouse's YouTube channel in March of 2023. Further was discovered that Brandon Woodhouse had disseminated the information to several other people, and his YouTube channel was viewed by multiple viewers. Wow, multiple. Like, you have to know that Nick was like just dying to be able to put that thousands. But when he has to use the word multiple viewers, it's pretty bad. It's, I mean, like what, 12 people saw that? I don't know. Okay, this dissemination of material, like he even used the term, like the air quotes, or quoted the term leak for it, because it's not a leak. Dissemination of material from the case is a violation of that gag order and directly relates back to defense counsel. Okay, and now I'm going to point y'all back. Okay, right back to when we started this thing off, talking about it being willful. Okay, that is not willful. Him accidentally sending an email to a former client that happens to have the same name as his partner on the case, and an auto-populated email. Sloppy, yes, definitely. But willful? No, absolutely not. Allison, you're muted.
Unless it was the accidental email on purpose.
Right. And if you guys don't know what that's from, it's from the incredible show Curb Your Enthusiasm, which the final season starting February 4th, by the way.
Wow.
I'm super depressed about it. I watched like I watched 2 or 3 episodes last night. It was so great. All right. So what did you guys do to like fix? I actually want to see, did you do anything?
I went up there. Darren actually wasn't watching. I grabbed some pretzels because I'm starving, and I came back down and it was all fixed. So I don't know if it actually.
I'm not sure if I gave you, did you ask for a break? All right. So, yeah, your MacBook is on the right thing. Like, you shouldn't be freezing up. I just don't get it. Our internet sucks, man. And if you can hear us, Metronet, I'm talking to you. It's ridiculous. All right. Sorry, guys. Okay, that on February 13th, 2023, the state filed a motion requesting a protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case or to the public. That on February 17th, 2023, the court granted the state's motion and put in place a protective order setting forth very restrictive rules to prevent dissemination of the discovery in this case to the public or to anyone not involved in the case. Now I'm going to pull up I think this is the protective. Okay, get rid of the blue. Okay. All right. So I believe I just want to check the date. Yeah. All right. So this is the protective order. Allie, keep your mic on. Quit muting. Why are you muting?
Well, because if I cough or I actually chewed a couple of other little pretzels and that's why I was
All
turning.
right, I take it back. If you're crunching on pretzels, then yeah.
But just go right to the part that actually says what they can and can't do.
Well, it's a very short order, hon.
All right, go ahead.
Okay, dude, you're off that PCRA tonight. I'm sorry. Like you're not rushing off to go. Like
no, I'm not. I just want to get to the juicy discussion.
I mean, this to me, it's all juicy, all juicy.
All juicy.
All right. Okay. So, McCleland, I'm getting sound coming through yours. Like I heard me coming through yours. All right, so McCleland requested it. Okay, and these are the rules: that one copy of the discovery material shall be provided to counsel for the defendant. That no additional copies of the discovery material shall be made by the defendant, defendant's counsel, investigator, expert, or any other representative or agent for any reason. 3, that the discovery material shall not be used for any purpose other than to prepare for the defense in the above reference matter or a cause number. That the discovery material shall not be publicly exhibited, displayed, shown, used for educational, research, or demonstrative purposes, or used in any other matter except in judicial proceedings in the above referenced action. That the discovery material may be viewed only by parties, counsel, and counsel's investigators and experts. That if copies of the discovery material are made and provided to the defendant, investigators, or experts for the defense, that sensitive and private information contained in the discovery shall be redacted, including any social security numbers, IDAC information, or NCIC information, any information related to the personal information of the juveniles, including social security numbers, names, date of birth, and FBI Sentinel information. Okay. And then 7, that none of the discovery material shall be divulged to any person not authorized to view the discovery material. This includes other witnesses, family members, relatives, and friends of the defendant. And can you see it, babe? Is it big enough? Okay, that no person other than the defendant, counsel for the defendant, and those persons listed in paragraph 6 shall be granted access to said discovery material or substance of any portion thereof, unless the person has signed an agreement in writing that he or she has received a copy of this order and that he or she submits to the court's jurisdiction and authority with respect to the discovery, agrees to be subject to the court's contempt powers for any violation of this order, and is granted prior permission by this court to access said discovery. Okay, that upon final disposition of the case, the discovery material referred to in paragraph 1 and any and all transcripts shall be returned to the Carroll County Prosecutor's Office or maintained by defense counsel pursuant to the terms herein. And then 10, the counsel of the defendant shall be responsible to ensure that all persons involved in the defense of this case comply with the order, and that written documents, records provided by the state with the discovery material fall under the same rules as described above. Okay, and that's it. So there's the whole thing.
So he probably should have focused on that part right there. I mean,
Which part?
that's the part where they're talking about that you need to have people sign this if you're going to, most of this dealt with actual documents, but I thought that paragraph, there was a paragraph that mentioned if they're conveyed any parts of it or something.
What of the order?
Yeah.
That none of the discovery material shall be divulged to any person not authorized to view the discovery. That includes witnesses, family members, or relatives, or was it something
So it
else?
was something about like a portion or a. Oh, there it is.
Where?
10.
10.
The last line. Or the substance.
Misnumbered. It's weird.
The substance of any portion thereof.
Where are you reading that?
It says 8.
Oh, paragraph 8.
Sorry. Okay. I thought it was 10 because it was right above 11.
Yeah, it seems to be misnumbered because it's got 8, 11, 9, and 10.
So that's what I'm saying is
typical Delphi.
That's what they could have relied on as actually violating this order, that there was information conveyed to people who hadn't signed something submitting to the jurisdiction of the court, and the court didn't specifically authorize, which just seems a little excessive, but still.
It does. All right. Let's get back to it. Because now we've got the background. We've read through the gag and we've read through the protective, and they're different. Like y'all can see that they're two different things, right? Because they are. One is dealing with the media and them in the media. The other is trying to keep the discovery, the facts of the case, quiet and out of the public eye. All right.
Not
okay.
Totally.
So there's on the 17th, the court granted the state's motion to put the protective order in place. That on October 2023, the state was made aware by the families of the victims that crime scene photos were leaked to the public. Indiana State Police began an investigation into how the photos were leaked. It became immediately obvious that the leaked photos came from the defense. On September 18th, 2023, the defense filed a Franks motion with a memorandum in support. The memorandum described the crime scene in gory graphic detail. As a part of that memorandum, the defense attached exhibits that were provided in hard copies to the state and the court. Some of the exhibits were side-by-side photos that the defense created. Okay, so they're talking. So like you and I were trying to understand this. Okay, so what they're talking about there is that the defense took two crime scene photos, put them side by side, and then took a picture of it, and they created that. Because this language really like set me off when I read it at first. And that part I don't mind. And photos of the crime scene that the defense had altered.
Which if he's talking about the same thing, then he's being disingenuous in his language. If there's not actual altering of a picture. Okay,
it's like suggesting that the defense is altering evidence in the case is
outrageous.
Like I need him to clarify.
He sure as shit better have his receipts.
Nick, if you're out there in the chat, which I wouldn't doubt that Nick watches, to be honest with you. Why don't you let us know what you meant by that, dude? Because I'm curious. Are you suggesting that the defense is altering photographs that they intend on using in evidence? Like that they're making up fake evidence? Or am I just misreading that? I'm curious. I really want to know what he means by that.
I honestly think that he could be using that language, but just referring to the fact that he altered crime scene pictures by putting them side by side with something.
But why use a different word?
For the purposes of what you just said, misleading the public.
Man, see, that's the thing.
Unless there's something else that we're unaware, but if there's not, then he did just mislead the public.
Well, and it's worse than that. Like it gets worse than this. Because when you read this very carefully, what the takeaway from it is, and it's going to be, it's not in this paragraph, but I want you guys to remember this paragraph, because when we get down, remember that as part of the memorandum, the defense attached exhibits that were provided in hard copies of the state and the court. Remember that for when we get a couple paragraphs down. The investigators were led to a podcaster who said that he got the pictures from an individual that he knew. The investigation led officers to determine the podcaster got the photos from a man that he knew, who got them from Robert Fortson, rest in peace. Robert Fortson received the photos from Mitch Westerman, former Baldwin associate friend, worked in the office. That's the guy who was the leaker, who is tied to the defense. Then on October 10th, 2023, defense counsel Andrew Baldwin stated on a conference call with all the parties that a trusted confidant by the name of Mitch Westerman stopped by his office to visit. He snuck into the conference room where all the discovery in this case was being held, unsecured, and took photos of the crime scene pictures. Defense counsel Baldwin stated that this occurred without his permission and that the pictures were stolen. Ironically, this was hours after investigators spoke to Fortson and determined that Mitch Westerman leaked the photos and that he was the connection to the defense. So he's insinuating that Westerman gave Andy a heads up and that Andy said, "Oh my God, I better call the judge." You know what I mean? I mean, if Westerman did say, "Yo, man, I got bad news, bro." Like I was in your conference room and I took a bunch of pictures of the shit you guys had laying around, including crime scene photos, and my goose cooked. They figured it out. And like, I wanted to let you know. If that's how Baldwin became aware of it, but I don't think so, because of Rozzi's letter, which we're going to look to.
It's a lot less
they became aware of it on the 6th, is from what I understand.
What you just said is much less insidious than what's being implied here, which is that he knew all along, and then once he knew that they knew, then he sent the email. If what you just said happened is much less insidious than him.
Right. Like I was trying to make it that like that's the less insidious way that might have happened.
Right.
Because he's definitely making it insidious in terms of what he's implying.
Correct.
Yeah, I'm not trying to minimize his insidiousness.
No, it cannot be minimized.
Insidious.
Very insidious.
You're being insidious, Nick. All right. Paragraph 15, that the investigation by the Indiana State Police revealed that Mitch Westerman previously worked for Baldwin and was a person Baldwin trusted. In an interview with the Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memo. This is the paragraph I want you to remember, where he's talking about how the exhibits are attached. Okay, because what he implies here is insane. Okay. And this is the most important part of this paragraph. In an interview with the Indiana State Police, counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memo to review. Baldwin also stated that he gave the Franks memo to another civilian to review. Frankly, pleadings are pleadings. Pleadings are not discovery. Like, pleadings are filed on the public docket. Pleadings are how lawyers talk to the court. This is how we make our arguments. That's what pleadings are. That's what motions are.
They did contain the substance of discovery. What? I mean, they did contain the substance of what was learned in discovery.
Oh, you're saying that the memo itself, or are you talking about the exhibits?
No, the memo. I would hope he didn't give them the exhibits.
Well, that's what you want to talk about, insidious. That's what this paragraph implies.
I mean, he says it outright.
So it's like we have that sentence. So this sentence is, in an interview with the Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memo to review. Baldwin also stated that he gave the Franks memo to another civilian to review. The Franks memorandum and exhibits contained protected discovery information that included very sensitive crime scene photos that were leaked by Mitch Westerman. He is insidiously implying that he gave both of these guys the exhibits and not just the memo, which there's no way in hell he did.
I think he's also implying that the fact that the very same photos that were leaked are the very same photos he was using as exhibits speaks to him being more directly involved in the leak.
Right. Exactly. Well, for certain. Exactly. Specifically, the investigation revealed that Mitch Westerman gave the photos to an individual named Robert Fortson, who then passed them on to the individuals who distributed them throughout the internet. So he's insinuating both things. One, that he gave both of these guys the exhibits, which included the discovery pictures, okay, the crime scene photos, and he's also implying that that was what the actual leak was. Not that this Fortson or that the Westerman affidavit is a bunch of bullshit, like that this guy didn't sneak into the office and took that Andy had given him the memo, and along with the memo gave him the crime scene photographs along with the other exhibits. And there you go. That's how the leak happened. That's what that's insinuating to me. That's the way I read it. I don't know if people in the chat want to tell me I'm reading it wrong. Let me know. That's how I read that thing. Then on October 12th, Counsel Brad Rozzi submitted a letter to this court admitting that both he and Baldwin had agreed to store the discovery in the conference room in defense counsel Baldwin's office. Further, Rozzi admits that Mitch Westerman had access to the conference room and took the photos. Finally, Rozzi admits that it was negligent on the part of the defense counsel to allow Westerman alone in the office where the sensitive discovery material was stored. See Section 4 of the letter filed with the court. Then in Section 10 of that same letter, defense counsel accepts responsibility for a lapse in security that caused the photos to be leaked, admitting to this court that they are in direct contempt of the court's orders. It's still not willful. It's still not willful. Nick, you don't know what willful means.
It's the exact opposite of willful.
Right.
He
Exactly.
willfully didn't guard it like he should have, I guess, but
I mean, clear at this point, I mean, we all know. Yeah, look, and we've talked about it. We had a bunch of people in the office, young lawyers, all kinds of stuff. That
we're not going to go through 246 pages.
No, hell no. Relax. God, no. Yeah, I'm going to torture you. I'm going to read. Now I'm going to read through 240.
Oh, this is the index. I haven't seen it. Is that what this is?
Yeah, I'm going to Brad's letter.
Wait, no. That index is somewhat important. I'd like to see that.
This is the record of proceedings. This is.
Oh, it's not the index. Okay. No. Sorry, guys. Not the index.
No, there's got to be a way. Like, why am I not? Hold on. I got to blow this up so I can see the slider. I got to slide this thing down. Oh my God. Like I can't see the slider.
You can pick a page number to jump if you know.
Oh, thanks, babe. You're so smart. I think it was in 196. Okay. Oh, geez. We're still in the we're still in the memo. All right, hold on. I'm close though. I'm close. Okay. Because I want to pull up Rosie's letter. So here's the letter. Okay. Let's make sure that what Nick's stating in the old motion here is what Brad's saying. Because I'm assuming this is the letter he's talking about, all right? Okay. All right, so facts, Andy has 3 separate locations. Andy had a personal office which sits next to the conference room throughout this case. We had utilized the conference room as our home base, which we would call a war room, in terms of storing diagrams, photographs, and other exhibits that are involved in the case. We've also used the conference room for our defense team meetings and to generally review discovery, which is what happens in the war room. This includes searching through 20 or more hard drives that we have been provided by the state, various thumb drives, and other discovery documentation. I would estimate that 90% of the discovery materials are located in Andy's office. Andy has a buddy named Mitch Westerman. Mitch has a law degree, so he has a law degree. Like, he's not a lawyer, he's not licensed, but he has a law degree from Valpo. And at one point in the past, worked as an employee at Andy's firm. Mitch is also Andy's personal friend. It's my understanding that Mitch had a girlfriend in the Franklin area and therefore would routinely pop in. Hey, what's up, man? Doing a pop in.
The accidental pop in on purpose.
Yeah, the accidental pop in on purpose. By the office when he visited his girlfriend. And Andy communicated to me that Mitch was a fairly skilled strategist and that he would sometimes communicate ideas and circumstances with Mitch to get his feedback. Andy reported that he did this on occasion in this case. Okay. At no time did Andy ever authorize Mitch to duplicate or take physical possession of any exhibits or documentation in this case. During the week of the 2nd, the defense became aware of a gentleman in Texas who claimed that the crime scene photos had been leaked and that Andy was the party who leaked the photos. Okay. Naturally, this caused for some immediate disclosure, and Andy and I discussed the matter and believed that it was important to communicate our concerns with the prosecutor in the court. This disclosure was accomplished through emails that you received from us last week. I was going to pull up the emails. I think we've all seen them. Many of us have seen this already, but on Monday, October 9th, Westerman showed up at Andy's office and asked for a few minutes of time. So this is the 9th, the day before the 10th, that Nick is talking about in the memo with the call. That, like, miraculously 4 hours after, the deposition and the photographs, and then Andy all of a sudden is calling, right? So it says, so on the 9th, Westerman shows up at Andy's office and asks for a few minutes of Andy's time. Andy reports that during that conversation, Mitch acknowledged that he had made a mistake and, in fact, took it upon himself to access Andy's conference room and photograph some exhibits that he discovered laying on the table. We believe that this occurred back in August when we were preparing for the first round of depositions. In fact, Nick later confirmed that the prosecution, believes that the docs possessed by Westerman are the same or similar to the exhibits that were offered up during this deposition. That's a very different statement than what Nick says in his verified complaint, right? Or his verified statement of facts. Okay, so he says, and it goes right to this language, that Baldwin admitted that he voluntarily gave the copy of the Franks to a couple of different people, and that it was where's that language? It was down here. Where is it? Where was that?
I can't see anything. I thought you were right above that.
Was it in the paragraph right above it?
I think it's right there. Literally right where you were.
Oh, okay. All right. Previously, this is where I just was. The Franks memo and exhibits contained protected blah, blah, blah. Specifically, the investigation revealed that gave photos of an individual. Now, I want the thing where he's talking about greed. God damn it. Where'd it go? All right. It snuck into the conversation. Oh, wait, here. Okay. All right. It was the side-by-side thing. Okay. So this is where it's different. Indiana State Police began an investigation on the photos of the leak. It became obvious that the photos came from the defense. On September 18, 2023, the defense filed a Franks motion with the memorandum of support. The memo described the crime scene in gory graphic detail. As part of the memo, the defense attached exhibits that were provided in hard copies to state and court. Some of these exhibits were side-by-side photos that the defense created and photos of the crime scene the defense had altered. These photos were the photos that were leaked to the public. So he's not saying what Rozzie's saying.
Although Rozzi seems to just be saying we used those in a deposition long before the memo anyway.
Right, but you have to remember he then goes down and he's talking about the 10th, October. So on the 12th, this is when he submits the letter but on the whole thing with him on the 10th, talking about how Baldwin conveniently calls. So then on the 10th, so like Rozzi's thing talks about the 9th when Westerman comes in. And then on the 10th that Baldwin stated on a conference call with all the parties, that tells him the Mitch story.
Right.
Okay.
So this is just in bad faith. He already has the facts that counter his position.
Right.
Unless he, like you said, unless he has some receipts somewhere that disprove that.
If he has receipts, why isn't he attaching them to this thing, this motion for,
Right.
Like why aren't you attaching them to that?
I'd like to know why he's even asking for civil contempt. Like, pay attention to your case. Can we deal with the case?
Oh
like,
my
why
God.
are you worrying about whether or not the lawyer should be held in civil contempt for something the court has already addressed? The Supreme Court, in essence, has already addressed. If the judge wants to have some sort of, hearing
That's
on
the whole thing. Like this, like Nick is doing with this exactly what Nick and everyone else is accusing the defense of doing with the memo.
Right.
Like this is getting out there. Like he wants this up, like out in the press, out in the media, everyone talking about it, everyone reviving this, that this was all the nefarious shit that the defense was doing. Like, I mean, it's no question that it's insinuating that they intentionally divulged the photos. Like, to me, that's the way it reads. It's like he puts in the statements that, look, I know that that's what these guys were saying, but look at the facts. Like, are you buying that? I mean, it's like, it's just the way the thing reads.
Yeah.
Okay. Do we need to even read any more of this?
Nope. Absolutely not.
Okay. All right. Excuse me, y'all. Okay. All right. So wait, I was definitely past that. We don't want to be rereading. Okay. So we were further defense counsel Rozzi admits that Westerman had access to the conference room and took the photos. Finally. Okay. So this is where he admits that, he's in indirect contempt of court, which he's not. It's not willful. That's not willful. That is not willful. Willful is like when you have a court order.
It's on purpose.
The judge says to do something, and then you do the opposite of it.
On purpose.
That's willful. On purpose. Purposely, correct. All right. Then on October 18th, Westerman submitted an affidavit to this court stating that he, in fact, went into the conference room of defense counsel Andrew Baldwin and took pictures of the discovery evidence without the permission of defense counsel Baldwin. That investigators were able to retrieve messages from Fortson and another individual that showed that Fortson had detailed real-time knowledge about when the evidence was submitted to the defense and the contents of the evidence for weeks before the photos were leaked. Fortson also knew the actions defense took in trial preparation, leading law enforcement to believe that this was not a one-time act of one person, but a consistent leak of information and discovery in the case. The investigation showed that Westerman would get information about the case and then give it to Fortson, who would then distribute it to other individuals. Okay. So his leak is Andy's text messages. He's texting Mitch. And this is where we're going to get to
they're going off of Fortson's right there. They're going off of Fortson's text where Fortson's being told things by Mitch that Mitch in turn learned from Baldwin.
Right. So, but this is where we're getting into the really interesting shit. Okay. In terms of did Nick show his hand way too much in this thing? Okay. The investigators attempted to interview both Mitch Westerman and Robert Fortson, each of which declined. Okay. That shortly after investigators attempted to interview Fortson, he took his own life. Rest in peace. An investigation into that death, into that death led law enforcement to find out that shortly before his death, he had expressed concerns about the open investigation concerning the discovery leak in this case and stated to someone that if he just came clean, all this would go away. Okay, so here's where it gets juicy. That a search warrant on the iCloud account of Mitch Westerman revealed screenshot photographs of conversations between Mitch Westerman and defense counsel Andrew Baldwin, wherein they candidly discuss the Richard Allen case and candidly talk about the court and the state displaying a free flow of information that is protected by the court's gag order and order protecting discovery. Okay. The investigation shows that defense counsel failed to secure evidence and discovery materials in this case, specifically graphics crime scene photos, which were then distributed to the public and put on the internet in violation of the court order dated February 17, 2023. And the evidence supports a conclusion that disclosure was ongoing. All right. So this raises the issue. So subsequently, Westerman is arrested, okay, as part and parcel of this investigation in a different county, okay, which Nick McCleland is not the prosecutor handling that case.
Nor typically do you have jurisdiction, police have jurisdiction to investigate offenses that occur, especially deaths that are deemed suicide, occur in another county.
Well, this is the Indiana State Police, so they have jurisdiction. So this is ISP.
All right. Well, he doesn't.
Right, Nick. Like, I don't care about Indiana State Police. They're doing their job. As far as Nick being privy to any of this stuff, and this is where it gets sticky.
Wholly improper.
Because it's
attorney work product.
It's 100% attorney work product. If you and I are discussing our strategies or our theories with a confidant, and we've done it on every case, you know, it's like you can't be in an echo chamber. You need to be able to discuss case theories and does this fly? And if I were to say this to you, would you buy it, or would you think it was ridiculous? You know, any of those kind of conversations, any kind of theories, personal thoughts on the case, those are all attorney work product, which now Nick McCleland has admitted that he had access to.
And ISP should know better as well.
He 100%.
Why the hell would they?
Like whoever was heading the investigation for ISP should have been like, yo, Nick, look, I'm telling you right now, dude, like we got a bunch of discussions between Baldwin and another dude talking about the case. It seems like it's work product. It seems like even if he's confusing with privileged information, which are two different things, like privileged information and attorney work product are two different things.
Right. If he was telling him what his client said.
Yeah. Whatever that cop would have said should have caused Nick to say, man, no, I can't look at it. It's attorney work.
Exactly.
Product.
And just so everyone knows out there, if the police have a wire on someone's phone, for example, and they hear them get on first of all, they've got like 5 minutes to determine, all right, these people are not talking about anything illegal or whatever. I can't speak to the exact time, so don't hold me to it. I want to get someone out there. But anyway, if they're talking to their lawyer, it must get shut off. They are not allowed to listen to that. In the same sense, like Bob's saying, if the cops realize that they are seeing attorney work product, which is very obvious, as soon as they start to read it, they have to not review it. And they surely cannot share it with the prosecution who is prosecuting the case in which is being discussed. I mean, it's so outrageous. He just, as far as I'm concerned, wrote his own sanctionable conduct right there.
Well, beyond that, which I agree with, obviously, I think that a motion for a special prosecutor has to be made immediately. This is like anytime there's a potential conflict that arises in a case, like we've had special prosecutors come in where they worked with somebody involved in the case years ago, and were the prosecutor, and they were frank about it. They were very forthcoming, and they said, look, we can't, our office can't handle the case, because that infects the entire office. It's not a matter of you just being able to take the one person out of the mix. The entire prosecutor's office is removed. So what should happen here is that a special prosecutor should be, even from a different county, like in Illinois, they float. Like special prosecutors, they try cases all over the state.
Right, and
And
especially
typically
like I
they're
just told you guys about the whole culture of corruption in Chicago. They've got numerous special prosecutors that handle all those people who are now alleging my confession was tortured, my confession was a lie, the cops did this, the state's attorney. So they're all of those are handled by special prosecutors. And Bob, you would agree that they should have put a special prosecutor in place to handle that investigation so that this one was clean. But now that they've totally effed it, they need a special prosecutor to handle Richard Allen's case. There's no way around it.
I mean, it's got to get filed. Like they have to file for a motion that a special prosecutor be appointed. Like there's no question. Oh, and I just saw Teresa, our girl from criminality, had portaled everybody over here. Thank you, Teresa. If you're in here, we so appreciate you. We adore you. And welcome all you criminality homies.
That was sweet. Thank you.
Yeah, she's amazing. And everybody over there knows I love them dearly. So we seriously appreciate that. All right, we're getting close. Like, I mean, that is our position on this. And I don't know who's talking about it other than us, maybe, some other attorney. That language right there, that he had access to attorney work product and like it backfired on him. He's trying to say, these communications where he's discussing trial strategies with a guy who graduated from law school, like he just doesn't know that Westerman's being a scumbag. Like we have friends that like we talk about, whether they're lawyer friends that aren't in our firm that like, that practice, and we've run cases by him and theories. Oh, we got this case. We do it all the time. That's like when you're in private practice as a defense attorney, you need sounding boards. That's just facts. I mean, and let me just put it this way. I'm sure all of you guys have heard about people doing like lawyers doing like having like moot trials where they'll test their theory, mock trials, where they'll go in, they'll impanel, a mock jury, and they'll try their case. That's typically for people with a lot of money that can like afford to have their lawyers do this. Like I think like in the Michael Peterson case, they did like 3 or 4 of them. They kept having them, and they're like, but you got to have the dough to do it. But it's the same concept. You're trying to see if your theory is workable, if it works with the jury, if a jury's going to buy it. There's nothing wrong with that in the practice of law. There's just isn't. This whole concept that I kept hearing different podcasts and channels talking about, like them talking and throwing trial strategies back and forth and ideas and strategizing with other lawyers is not verboten. It's just not. Like it just isn't.
No.
So that's just not a thing. Now, where it gets sticky with the protective order, I mean, there's some argument there.
Yeah.
But there's no question about that. If he's disclosing things that fall under specifically the protective order, which is the discovery in the case,
which is essentially everything. So
which is essentially everything.
It's
so
hard to do any sort of mock trial or bouncing off in within the confines of that protective order.
Yeah, I mean, unless he doesn't violate like that, like as
that
far
doesn't
as
make his shit any less work product.
It's still those are 2 different issues,
right?
Like as far as I can tell, that might be the only willful conduct that I've seen in here.
But and I'm sure nothing will happen and come of this, but nonetheless, it still needs to be raised and litigated. But that the whole thing about this guy cannot prosecute this anymore. I mean, he's reviewed attorney work product. That
2
is
different things. Like McCleland has to be off the case. I'm sorry.
And it's going to be the same thing with it. Could possibly, I'd have to research it, but it might even be structural error. I mean, I don't know. We don't know what he's really seen, and I don't know if maybe I'd have to research the issue. Like, well, the attorney work product you saw didn't tell you anything, so we're not going to
But it
conflict you
sounds
out.
like it did. It sounds like because he's using it as a sword in this
Right.
particular motion.
Right. Oh yeah.
He's implying that it said all kinds of stuff.
He
It
surely
disclosed
is.
everything. So, and just so you guys understand, attorney work product is not discoverable, meaning that like if Allison and I have our thoughts, our theories written down on a notepad, and we've talked to a witness and there's anything that would be considered under the umbrella of attorney work product, it's not discoverable, meaning that we do not have to turn it over to the state, and vice versa. The state does not have to turn over their work product, their attorney work product, to us. Those are the things that are not discoverable. So this is a big deal. This is a real issue that's going to have to get dealt with. And unfortunately, the reality is that we are still stuck in the shit in this case. Like just when I thought we were finally going to get it moving forward again, we are. Is it even worse than it was before? Because now
new prosecutor
Baldwin and Rozzi are back. They're trying to DQ Gull. McCleland is trying to have this thing happen, which the end result could not be her removing them. The end result would be sanctions, like what they suggested, what Hennessy suggested. I'm going to dock you a week's pay, which is a substantial amount of money. They're working it's a lot of hours on this case. They would feel that. That is the type of sanction that they would feel. The end result of this thing is never going to be that they're removed from the case again. So for all y'all out there that think that that's what they're going for, that's not what this is. That's not the appropriate sanction for contempt. Maybe she throws Baldwin in jail for a weekend.
That'd be outrageous.
I mean, it would, but she could do it. She said it in the order. It's fines, jail. Maybe I throw you in jail. Andy, I'm tossing you in for a week. It'll be like my cousin Vinny style. He loved it. He loved it. He loved being in jail. He got good night's sleep there. Yeah, I mean, obviously that would be outrageous. But at this point, how do we say that anything's impossible? But
I mean,
the Nick McCleland thing, I don't know if you're hearing it here first, but you're hearing it here last. He needs to be off the case because of that. A special prosecutor has to come in, and you want it from somebody from the state, because otherwise the assumption is that Nick McCleland is then just going to pass off all the information that he has from reading these messages to the special prosecutor, thereby creating the same problem. Special prosecutors, in my experience in dealing with them, don't do that kind of thing. They take that job very, very seriously. They're typically, a lot of them come from the state capitol. Most of ours are from Springfield. Yeah, the AG's office. So, I mean, we'll see what happens, but I'm just telling you, and Allie's just telling you, that's where this thing needs to be. And it's his own fault. He should never have put that in there. He got too big for his britches with that language. Everything else, we know it all. He's not shedding new light on anything with any of this. Has there been anything in here that you've read that shed new light?
No, I just don't see how he doesn't see that he's doing the precise thing he's complaining someone else is doing.
With the memo. Yeah, I know.
It's like...
All right, let's wrap it up here. The investigation shows the defense counsel failed to secure evidence and discovery materials in this case, specifically graphic sign. I think I read this one. And that evidence supports a conclusion the disclosure was ongoing. Then on the 19th of October, and again at the hearing held on the 31st of October, Hennessy, attorney for Baldwin, suggested for the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. And that the state was notified in the beginning of the leak, and he always puts it in quotes, by the defense, by the victims, the families of the victims. Since that time, the state has had an opportunity to talk to the families of the victims about the photos and the information that was leaked. The amount of harm and re-victimization that this has caused the families of the victims is unmeasurable and incurable. And that the press release and the two occasions of leaked information show a trend by defense counsel Brad Rozzi and Andrew Baldwin of not being completely honest with the court. Wow, violating the gag order.
That's it. We're done with it.
Yeah. Wait, like I want to read the last sentence because it seemed.
Okay.
Hold on. Oh yeah, in violating the gag order set in place to protect the integrity of the case and failing to
All right.
comply with the
They don't
protective
need that.
order.
They got it. They got it.
All right. Okay.
All right. So, I mean, this is obviously the biggest thing, like that the search of Westerman's iCloud, and it's just
It's
too
the
much.
biggest thing. All right, talk about it for a second. I gotta go get a drink.
All right. So I just wanted to pull Candace's comment back up because it's absolutely true. And the fact of the matter is, it's very obvious that they were hoping and expecting to find something like this, which could have triggered them to appoint a special prosecutor, because that's a thing. Like, for example, you've got all these wrongful convictions in Chicago, and there's one family who their children were arrested. It was so ridiculous. And then they filed a motion to have a special prosecutor assigned to investigate the crime, because the city was no longer investigating it because they were acting like the kids who were deemed to have been wrongfully convicted, or the charges were dismissed, whichever the case may be, that they're not investigating. So it could have been done preliminarily so that the prosecutor's office, those prosecutors, didn't find out any of the information in there, because the police need someone to be communicating their case to. So that's how, like, if they put in a special prosecutor, that special prosecutor would use their investigative force to investigate. So it does, it's very unfortunate, because I'm sure Judge Gull is not going to feel the same way that we feel, and that something's not going to happen like it should. And then it'll be an appeal issue. It's not going to be like you took their lawyers off kind of redo, but I'd have to look at how seriously. It's not an issue that I've researched personally.
Yeah, and let me ask you. So, my prediction, and just so everybody knows, and I think I touched upon it with respect to Gull. She sits on her own DQ hearing, just so everybody's clear about that. She's clear, and that can only go one of three ways. She can either deny it without hearing. Okay, she can have a hearing and deny it, or she can decide to withdraw from the matter and skip the whole thing. So, I mean, I have no idea what she'll do. If I were her, I feel like, man, screw this case, dude. I'm over it. See ya. I'm done. Thanks, but no thanks. Y'all can deal with all this nightmare, and I'm good.
And I think it does definitely, as we've sort of been saying, and I know a lot of these, comments come up before we touch on them, because it's the things in everybody's minds, but that it does seem desperate, and it does seem transparent. And again, if he was really just asking for what he asked in the motion, I want that sanction you spoke to. Are you seriously wasting your time, the court's time, when you're dealing with a double homicide, to seek that little slap on the wrist that you want so badly? No.
Yeah, I mean, there's ulterior motives for certain. We had seen this one already.
Yes,
right?
I know. Sorry.
Are you putting some up? So, the way that I see this thing shaking out, she's going to, the first thing that she has to deal with, because she cannot rule on this either. She has to deal with her DQ first. That is the first order of business. And, the thing that just blows me away is that no one waited for the opinion to come out. Once the shit started rolling downhill, it was Gull did her thing.
The defense had no choice after that.
Exactly. She does her thing. They're like, oh my God, we got to get rid of her. she's not considering our former like pleading to be valid. So I've got to refile this thing. I'll beef it up. They filed that. And then Nick, I think, was probably sitting, waiting. Like he had this drafted up. Like as soon as he got like the opinion came down, these guys were back. He started drafting this thing up. And he was probably going to wait until the opinion dropped before he did this. But as soon as they dropped in the morning, he's like, oh, that's it. Screw these guys. I'm filing it. And then there it is, So, I mean, the question becomes, can she even sit on this sanction thing?
I don't know.
I don't know. It's like,
it's a sanction. What is the, like sanctions are more typically the purpose for the sanction right now has almost lost its purpose because it's to prevent future, it's to make you feel the ramifications to prevent future violations. I think they've done that. I think they've accomplished that. Seeing as we've been all the way up to the Supreme Court, they've been removed. I mean, there's been a lot of punishment for that action. It's just clearly not what the state's focus was. And I just hope that other people see it as clearly as most of our listeners and viewers. And
people are very divided on I think at this point, I think most people came to the conclusion that she overreached with removing them, even on people that were like, yeah, the horrific nature of the leak. And that like people confused what I was saying about that all the time. Like
it's all right.
And people but the lawyers, the defense lawyers didn't care about everyone knows leaks are awful. Like we hate leaks more than anybody on the planet. Like they try our clients with leaks all the time, not just in this case, every case. Garcia, they were leaking case, like everything was leaked out by the press and the prosecutor or both. I don't know, law enforcement, constant source of leaking. And that case was not gagged, which it should have been.
Yeah. They wouldn't do that. They had the press in the chambers. Are you kidding me?
They literally had press in the chambers. It was crazy.
And I just do want to reiterate the fact that I'm going to put it this way. If the defense attorneys actually, intentionally, not accidentally on purpose, but, on purpose, did this getting the pictures released, they are the worst defense attorneys known to man, because no defense attorney and every defense attorney knows you do not want victims' pictures released to the press. It does not help your case at all. It
destroys your case. It destroys the case. It's like it sets the entire world against your client, like where evidence doesn't matter anymore. It's like if those were to become public, like at large, like Richard Allen's a dead man. Metaphorically speaking, like he's going to get convicted because somebody's paying for that,
it makes it a lot harder. Right.
He's a dead man. If that happens, like if it go like defense attorneys just would never do that. It is like the worst thing. Like we fought like hell in Omaha to keep that shit out of the press. Oh man, it was like people just don't understand it. So can you answer this question for Angela?
I was just trying to not say it as a question so it didn't bust the flow of the future editings. But in any event, if the judge refuses to recuse herself, my understanding on Indiana law is that that might be the end of it. That might be, okay, now we have to just put on our big boy pants and deal with what we've got.
Facts.
So we know that we're dealing with a civil contempt here, not criminal. And I know that Bob has explained the difference between indirect and direct civil contempt. And again, just going back to that discovery index, it may or may not be, it just depends, the index alone, I mean, technically anything the lawyer does is work product. But if it's doesn't have any mental, I can't think of the words right now, but it, impressions, and it's just an index. I don't know if that would be work product, but definitely anything, not, it doesn't even have to go as far as strategy, just a mental impression, your thought, a plan. I'm going to interview this person. I mean, anything. It is attorney work product. And I think it's very likely that an index could have attorney work product in it, just depending on like how you organize it or something that you might call it. And if you use capital letters in something that you don't use in others. So most assuredly an index could be work product. And
100%.
yeah, this is not something that happens typically, but you see it. And I do think, as far as the prosecutor working so hard to get rid of the lawyers, you do see it when they are intimidated, I think, especially since that's why I think they did it to me. I know we keep talking about this Garcia case, but it was a serial, it was a case with multiple homicides, and there was a lot of similarity in the way that the prosecution was treating the defense. And so it does, to me, and as we've just said, it does reflect very poorly, because he's identifying the fact that he is knowingly seeking out work product in this case. So
there's no, I mean, he got it. I mean, there's no question about it. So, yeah, this thing is not ending up with them being removed from the case. This motion, that is not the end game for this particular motion. A rule to show cause, which is what they call it in Illinois, rule to show cause as to why you shouldn't be held in direct civil contempt, is not an end game where they're getting removed. There's like, if she'll impose a sanction, and I'm assuming that if she's still on the case, she's the one who's going to hear it, and it can't be heard until they deal with her DQ. Her DQ is the first order of business that's going to have to get dealt with.
yes.
Let's see. We got anything else?
You've got right there what I had up.
Oh, I'm sorry. Pop it back up.
And this was, so just to explain better how the police got their hands on the text messages between the defense attorneys and Mitch was, once Mitch, is it Westerhouse?
Westerman.
Once Mitch Westerman was arrested, I mean, I can't even say it with a straight face, because it's clearly intentionally designed to get at work product, because it's a conversion case. So why they would get why they would get a warrant for his iCloud.
For an iCloud, for somebody's iCloud, and a misdemeanor.
But let's pretend it's a misdemeanor they really want to investigate. But again, you have to have a nexus in the law when you're looking for evidence. If you're looking to search, you have to be able to explain to the court, and I called it a nexus, but the connection between the evidence you're looking for and how it correlates to your crime. You have a crime of theft. So what in the hell is going to be in his iCloud that proves to you that he stole something any more than he's already put on paper saying, I snuck in, I took it without permission, I did it. So what the flip do you need his iCloud for? And why are judges signing warrants for, electronic evidence needs to be the warrant for an electronic evidence needs to be like very, very tight. I'm looking for this time period, for this information, for the whole purpose of not letting them just in to all of your private information. I mean, it's just absurd all the way around. It was designed to get this information. I don't even care if the lawyer accidentally on purpose did it. it still doesn't warrant this level of investigation. It just doesn't.
Yeah, no, I mean, it was clearly a sham. I know people were out there were really digging, trying to find the affidavit for warrant and Westerman thing because they
Does
wanted to
anyone even
see.
have the warrant itself? Was the parameters of the warrant limited to discussions at, I mean, what? He literally signed an affidavit. He literally signed an affidavit that says, I committed conversion for all
Right.
intents and purposes. There was no need for further investigation. I want to know who else is involved. So now you want to charge someone with conspiracy to convert?
Well, it was their fishing expedition to try to prove that the defense intentionally leaked the photographs out. I mean, this isn't a mystery. Like
Yeah,
this,
but
the
that's not
100%.
investigating a crime that they're supposed to have jurisdiction to
I
investigate.
realize
Although
that. I
they could be
agree.
doing it. They could be doing it under the guise of, we want to catch all who conspired so we can charge them all with conspiracy to convert.
It'd be the
Okay.
biggest turd case in the history of turd cases.
I
It's
mean,
it's the big RICO conversion trial that will all be just
what we're
bored as
going to do next time is bring up the prosecutors ethical guidelines and parameters and maybe start talking about that, because the guidelines dealing with prosecutors is it's stricter than it is for your average lawyer because of all of the power that they yield.
definitely. Yeah, that is interesting. That they were the same photographs that were used
Very
at the
good
death.
point.
Very, very interesting. Well, that was like entirely what I was trying to say.
But
That
we
these were
already know from Mitch's affidavit that he snuck into the office, took the pictures. So either he did that again without permission and it was like a wink wink, and I'm not, I know, these lawyers. So I'm not saying that is what they did. I'm just saying, if you take worst case scenario and that could have happened in the world, you still already have someone that says, I got it from their office and I released it. You know what I
Yeah, I
mean? So
mean, well,
I
what
don't think
Rosie was saying is that he believes that the leaked photographs were the ones that they were using for the depths that they had laid out preparing for their depths. Like when you go into a deposition and you're going to be deposing somebody, you prepare your exhibits ahead of time. Then you go in with your exhibits and you have them. And then when you're deposing your witness, you say, okay, I want to show you this photograph. Do you think that are you sitting here telling me as you sit here today that you don't believe that this photograph is
there's a
showing some
rune.
kind of like runes or somebody trying to mimic like a rune?
Are
I
you
mean, like,
trying to tell me
are
that
you
this
trying
is
to say that that's not a rune?
is that what you're saying?
Are you trying to tell me that that's not a rune? That is definitely a rune. All right, let's see. Oh, hater guy. I love that. Please stop referring
You
to
are
yourself as creative.
discussing and disseminating facts. He says, I love the passion and excitement. Thank you.
And
Not
we
a
thank
hater.
you. We hate. Sounds like a lover guy to me, not a
Right.
hater guy.
I thought you said, I don't know.
No, his name is Hater.
Oh, I get it. Sorry.
Yeah,
I
his
thought you
screen name.
thought his message. Sorry,
Like the
hater
only
guy.
way I could take that is maybe he hates on everyone else, which makes it even that much more of a compliment that he
Right.
just gave us. That
Yeah.
like typically he's hating on shit, but he's loving on us. Thanks for that $5 holla too, man. All right, let's kind of go through, do some thank yous. We've been rolling for 224 here. First of all, we love you all. You guys, please remember to like, remember to share, remember to subscribe. We try
All
to
right,
bring
wait
you
a
good
second here,
content.
babe. We're not leaving until every person who paid for a
I'm
comment.
going through them. I'm going to go.
Okay.
I'm going through them now. I was cutting it so that Darren can slice this off for the pod.
Oh, okay.
Yeah. So we'll go through. We're going to go through and give love to everybody. So if you guys don't want to hear the love for all the amazing people It
Don't
gave
tell him to
us
leave. We're
love.
gonna still be giving juicy information. We're answering all these que what in the hell?
Whoa, are we
I
battling on what we're
Yes,
putting? I'm
because we
starting at the
haven't
top.
well, I was
All right,
dealing with the
go there.
questions, and then you can do your whole just thank everyone for their thingy-majiggies
Okay, when somebody
after we
gives
do the
20 memberships, that's like 50
That's a big
bucks.
deal. It's a
It's a
big
big
deal.
deal, right?
It
So
warrants clear acknowledgement and
everybody's
all of
getting the
that.
love.
I was
All
just
right,
trying to deal with the questions first, but that's
okay,
fine.
fair.
And plus, I'm so hungry. All right. So, so I don't know who to call. Like I think it would be the Attorney General's office, but I don't know how many people would need to call there for them to pay attention. Um, but it's supposed to be all prosecutors' offices have something in place for when their office has a conflict of interest, who is supposed to take over, but they need to acknowledge that conflict of interest and ask for it, or somebody else needs to ask for it for them, which in this case would be the defense.
For sure. For sure. All right, so I'm going to start at the top here. All right,
I,
Benjamin Wyckoff, new member. Welcome, man. Welcome. Thank you.
hi, Benjamin. Thank
We
you.
so appreciate that. Oh man, Shiraz always comes through. 20
Sweet.
Defense Diaries memberships is amazing. Thank you so much. You're always so super generous. And the beneficiaries of that, I'm sure we're very thankful in the chat as well. So thank you a million times over. Teresa, Criminality, our girl. Look at that. Supporting other creators supporting creators. We love that in this community. I love to do it. I do it all the time, and I love when they do it to us. Thank you so much, Teresa. We adore you. I really, really love your channel. I think you're the money, the bomb. So thank you so much for that. Yellow Jacket, we answered your question. Thank you for the $5
Thank
holla.
you.
Appreciate you. Women doing impossible things. Love that. Thank you for becoming a new member. I've been seeing you in here, so we're super thankful that you're now a member. We appreciate you. And she loves you. That I could tell you. I think she
Me?
refers to you as queen. Yeah, you're the queen. Queen, I
All
love
women
that.
are.
All women are queens. I agree. And you went through Candace with the amazing $20 hollow, right? You answered
Yes,
that
and she
question already?
did. It was a very important question.
It was a very important question, and I'm sure you thoroughly answered it.
Yeah.
And this it is. I cannot believe no one has stepped in yet. No doubt. And thank you for that $2 holla. Charmaine with 10. Charmaine is always incredibly generous. Thank you
That's
so much,
very
Charmaine.
generous. Thank you.
Constant support means everything to us. We really, really appreciate it. Vape Allison, you are a queen. $2 holla. I'm saying, man. I mean, it's like it is what it is. You vape. What are you gonna do? Megan, $5 holla. Thank you so much. You're
Thanks,
all
Megan.
giving us the support too. We appreciate you more than you know. Travis, he's a member, and you give us knowledge, bro. Like you give us things that we use all the time. So we're always thankful that you're in here. We're always thankful that
There's
you've helped.
another question that he's got just coming up that we need to talk
Yeah,
about.
I saw it. I thought I put it up for a second. I think you got Angela's question. Yep. I think we got Ariel's question as well. I can't type in chat. Am I a member? Like that
That's
got
what
resolved. Right?
prompted. Well, clearly, because then she sent. I don't know. I hope so, but
Right.
I sent her. That's what got me when you were like, "Are you paying attention?" And I was like trying to. I guess I should have just messaged the mods, but I forget that there's that thing over that.
For real.
Um,
Dean, so I hope our mods are putting in our links all the time because
they are. It's happening.
So bonfires, we resell all our merch. We do not have the whole lot of Mata shirts, but they are forthcoming for certain. But we do have a bunch of great shirts. I wear some of them sometimes.
I mean, a modified shirt should be coming as well.
Yeah, man, modified for sure. It's like modified, like modified. It's pretty good. It's creative. We like it. We like it a lot. But yeah, and then y'all, like if you're into podcasts, remember this whole thing this is why we do this. And if you haven't
Yes.
listened to our Gacy season or our Garcia season, or Allie and I doing the docket, which a lot of these get converted into it, but we edited them out, we clean them up, and we're covering
Yeah, but we
Avery,
covered, yes, so much stuff
all kinds of Vallow
that
trial, and
the
it's
Valid
it's
trial is so
great
good.
content, and we really want people listening to the podcast. You'll love it. If you haven't listened to the Gacy and the Garcia thing, they're just you're not getting much Allie and Gacy at all, but you're getting Allie and Garcia towards the end.
I would
It's a different thing though.
The Gacy is the best. I mean, I know obviously
You're so biased.
I am, but I'm not kidding. The best podcast I have ever heard.
And it's 36 episodes. It is epic. If you like
amazing.
deep dives, and if you're
There's
not
anyone
into
that hasn't heard
Gacy,
it.
it's not a Gacy fanboy thing at all. Like what we
No.
uncover about the investigation, how they got Gacy is like, it should have been national news. It still will be. There's no question, because what we uncovered was insane. And it's about the victims, because I knew nothing about the victims going in, and about the investigation and the trial. It's all the stuff they never talk about in serial killer cases. And my dad happened to be the guy's lawyer. So we had the tapes that my dad had given me 30 years ago of him prepping Gacy for trial. And they're the creepiest, eeriest shit that you'll ever listen to. And we weave them into a long narrative story. It's like reading a book. It's like Audible. Like it's longer than most pods out there. As a matter of fact, I don't know, except for maybe Mandy Matney with the Murdoch thing. I don't know that there's a longer form, but mine's like ours. The Gacy thing is a story from beginning to end.
It's amazing. It really is.
I'll put it up against any other pod out there all day. So I'm remiss because I often forget to promote that on
You're
here.
supposed to put up. You were supposed to do it, convert it into YouTubes. I think Darren did like one.
I know.
That would you should probably still do that. We've definitely.
We are. Darren's still working on it. Darren's still working on it. And the things that I'm doing with Bill, Bill Dorsch on the second season of that, where we're boots on the ground trying to find other victims, is like those lives do not get nearly as many people as they like to love the Delphi.
Well,
case
right now, you guys, you haven't found any new people yet.
But we haven't been like boots up, but like we're giving people all the background.
We've definitely. Yes.
Okay. $10 holla from Debbie. We love you. Super sticker. Cammy Q.
Thanks, Cammy.
5 Defense Diaries podcast membership. Thank you so much. Charmaine, she just gives until it hurts. Charmaine, thank you so much for that $14 holla.
We did answer.
Yeah, she's great. She's amazing. Grace, thank you so much. Welcome to the family. We love having you here. Precocin, thank you. You are always
3 months.
3 months. Look at that. Boo boo. Man, that's like you're OG. I don't know if our mods like Stevie and Mandy are supposed to be making OG emojis.
I don't know. How do we use those emojis? I don't get it.
Well, we don't use them, but our listeners do. We
they're
can't
seeing it on their end.
Yeah, they
so
see
someone sees little Scarlett's face sometimes.
Yeah, or they'll see the just facts or the straight dope. We have various emojis that they can use. Oksana Luke, we love you for that $10 holler, and we see you in here all the time. We appreciate you always being here. We love that you're a member. You're such a valuable member of the community. Same with you, Tornado Artist. We love you, and thank you so much for that $5 holla. And Precocin came back for another 2. Special Prosecutor, boom, boom. It's got to happen. Forensic accountant for sure. All right, and this is where Travis was answering.
So Travis, I actually thought about that. I was like, well, I guess technically they could do an interlocutory appeal, but after at least talking with Kara, it just seems like they're almost never won. But what will be very telling on this issue is when the Supreme Court issues their ruling, because if they give some sort of hint that they don't like the way the Judge Gull has been doing things, or that they see issues, that might be a little signal to roll the dice and try an interlocutory appeal. I just think that they want to move forward, and it seems like Richard Allen has wanted to move forward, so it might not be worth that kind of, doing an interlocutory appeal. And like it needs to be pretty flagrant for an appellate court to step in and do something like that. So I don't know. I guess we'll see when the Supreme Court issues their ruling.
Man, I hope none of that shit goes on. Like they
Right, that's
just
what I'm
need to
saying.
move forward this case. It's like,
Yeah,
oh
I
my
don't think that they would do it.
Oh my God, it's just got to move forward. Like if anybody cares about the victims and the families, they just have to move this case forward. It's got to move forward.
Yeah,
And
but
we
they
do not
cannot
need to
ignore
be
things.
waiting.
But they cannot ignore things like a
I
motion
agree.
for a special prosecutor, because then that
I
issue's
agree.
waived. I mean, it's got to be at least preserved as an appellate issue for Richard Allen,
Yeah,
whether it happens here or not.
100%. All right,
Wait, why
Matt,
didn't you
did
answer?
you already wait because you're
Why'd you
skipping?
ignore that Game of Thrones thing? I didn't do
I
it.
know, but you're like going out of order. What did you
I didn't put it up there.
Oh, it must have been one of our
Mm.
mods must have thrown up. Did you deal with Matt? $10
No,
holla. Thank you, Bob and
no.
Allie. Why would Rosie be sanctioned since the leak did not take place in his office? Is it because they both agreed Baldwin's office was their HQ? I don't know, man. Like, I honestly cannot answer that question because, frankly, Rosie didn't do any of it. Like,
Right. I
it
don't think
wasn't
he
his
should be
watch. It
sanctioned at
wasn't
all.
his office. Like Rosie, like Nick likes to pick on Rosie in his pleadings, and he calls Rosie liars and in open court and shit like that. But as far as I could tell, Rosie's been just above board and top notch the whole way through, and Andy's a hell of a lawyer who just was definitely a little sloppy with keeping the room locked down. But like, that's the extent of it. It's like, Andy's not like some evil figure out there that's trying to disseminate pictures of beautiful little girls unclothed out to the world. That's not what he's doing. That was never his intention. Yes, he should be sanctioned for allowing them to get out, but it is what it is at this point. All right, so Andy, welcome to the family, brother. Shannon, $10 holla, super sticker. We love you, Shannon. We see you in here all the time. Dawn Burke,
$20.
She always comes in strong with the $20 holla. So appreciated. We love you. David James, $2 super sticker. Thank you, man. Thank you for your wonderful generosity. Oh, Gambies. We'll listen to the replay after work. Wanted to say hi and thank you to the models. Thank you, Gambies. You're always
she's probably gone, but she'll hear this on the
replay. She's coming back for replay crew. Oh, here it is. $10 out from David James. Which Game of Thrones house do you support? Stark, Lannister. Which one do you? Which house are you, babe?
I mean, I'd say the Starks.
100%.
Yeah, I mean, I'm like, am I missing my Game of Thrones stuff? But
what's
Lannisters,
left of the Starks? What's left?
Right.
I mean, it's basically Jon Snow. Jon Snow was.
I just don't remember when it got to the end, like where everybody stood, which house.
I actually like it would for me. It would be Stark, Targaryen, then Lannister. The Lannisters were just too incestuous for me, man.
Well, there was that
thing with I mean,
yeah, the incest. We get it.
Yeah, but that scene, the shaming scene where they were throwing the poop on her when she was walking down the thing, like when they were shaming her. Remember that scene? They shaved her head and were throwing. Yeah, it was good. I loved. Yeah. We loved the Game of Thrones, but the last when they outpaced the books, and they were waiting for him to finish the last book. It's like you could just see the drop in the quality of the writing. Because his stuff was, yes, you missed the verdict, post-punk mama. But remember for 2 years.
Joke again.
It's a thing with Jay. Right. And I feel bad because my boys over at Publicly Buzz were going live tonight. And
we should push these. Can't we do what?
Let me see if I can. Like, if
we're at the last person anyway.
For them, it's 11 o'clock. They're probably done. Like, so I completely screwed them.
Well, check. He stole
So the
all his
only way I can make up for screwing my boys at Publicly Buzz, because they're trying to dig into that crazy Kansas City case with the 3 buddies that were outside and ended up dead after they watched a football game at their buddy's house.
that I heard someone saying they probably went out to do a bump or something. I don't know
Yeah,
where
did a bump, like got a bad batch of blow is what I'm guessing. Like, so, but like
where did that
Steven,
come from?
what?
That theory that it was they went out, did a little bump, and
I mean, that was my theory. I don't know
Oh,
that
okay.
anybody else. Like, I mean, it
I
sounds like
couldn't remember if it was something I heard from you or I thought it was something.
I mean,
that
to me, it's the only thing that makes sense, right? But those guys, like Publicly
were they all
Buzz
like in the back?
Yeah, 3 of them were in the back. So one,
All
2
right, but
guys
go
were
on.
in
Sorry,
there.
you were trying to pitch.
Yeah, Publicly Buzz are my boys. If y'all don't follow them, it's like we got a bunch of. If you look on our page, you know, the shows that we consider family are Jay and Shannon. She's got her new show. And Jay is amazing. He does trial coverage. He's hilarious. He's my brother. And Joe Jackalone, former sergeant, former homicide dick with NYPD. Amazing guy. Really, really, really knowledgeable about everything. Oh, hell yeah. Joe tells secrets. Joe tells secrets out of school. You know, Joe's just a super knowledgeable guy. He's deep into the Lisk and Gilgo cases because it's his turf. So he's all over. So make sure you guys are subbing to Jay, to Shannon, to Publicly Buzz, which is Dan and Steve. And they're really ramping up. Like Steve has just started his Idaho 4 videos that he's put a ton of work into, which are amazing. So make sure you're checking out his vids. Make sure that y'all are subbing at all those places because they're our family. Like they're our creator family. And along with, we absolutely love Teresa and Criminality. Make sure you're subbing over there. And we also love the Grizzlies and Gisela. She's amazing. She supports us all the time. She's a really big show who gives us like a lot of love over there. So we're super appreciative of her because she's always so generous with giving us love. So if you aren't following her, make sure that you are, because if you're not, like, she's amazing. Like she puts together, and she's like in Europe. So she's like always like her time's way off. And she just like her ability to be able to snark on shit. It's like she's one of my favorite creators to watch.
She's
just
snarky.
She's super snarky, and it's like a lot of times just eye movement. She's just really good at like snarking with eyes, you know. All right, and then Shiraz coming through with another membership. Quit giving. You're off duty for tonight. Thank you. You're done. You're too amazing. Thank you so much. We appreciate you. And then Teresa asks a $2 holla. We love you.
Teresa.
Thank you so much. We appreciate your support. You guys have been amazing. We know you've kept you for 2+ hours going on 3. We hope he gave you some good content. We hope he gave you some straight dope. We hope he gave you just facts. And we hope you left with a little more than you came in with. And just remember, we love you guys because without you, I'd just be an old man.
Talking about a shit ton of cases.
Ooh, girl, you ain't never lied. Peace.